Section 10.5.1 Application for registration, verification. Subsection A Application for use of trademark. Paragraph 1. The owner of a trademark used in commerce may request registration of its trademark on the principal register hereby established by paying the prescribed fee and filing in the Patent and Trademark Office an application and a verified statement, in such form as may be prescribed by the director, and such number of specimens or facsimiles of the mark as used as may be required by the director. Paragraph 2. The application shall include specification of the applicant's domicile and citizenship, the date of the applicant's first use of the mark, the date of the applicant's first use of the mark in commerce, the goods in connection with which the mark is used, and a drawing of the mark. Paragraph 3. The statement shall be verified by the applicant and specify that Subparagraph A. The person making the verification believes that he or she, or the juristic person in whose behalf he or she makes the verification, to be the owner of the mark sought to be registered. Subparagraph B. To the best of the verifier's knowledge and belief, the facts recited in the application are accurate. Subparagraph C. The mark is in use in commerce. And subparagraph D. To the best of the verifier's knowledge and belief, no other person has the right to use such mark in commerce, either in the identical form thereof, or in such near resemblance thereto as to be likely, when used on or in connection with the goods of such other person, to cause confusion, or to cause mistake, or to deceive, except that, in the case of every application claiming concurrent use, the applicant shall: Clause 1. State exceptions to the claim of exclusive use, and Clause 2. Shall specify, to the extent of the verifier's knowledge. Subclause 1. Any concurrent use by others. Subclause 2. The goods on or in connection with which, and the areas in which each concurrent use exists. Subclause 3. The periods of each use, and Subclause 4. The goods and area for which the applicant desires registration. Paragraph 4. The applicant shall comply with such rules or regulations as may be prescribed by the director. The director shall promulgate rules prescribing the requirements for the application and for obtaining a filing date herein. Subsection B. Application for bona fide intention to use trademark. Paragraph 1. A person who has a bona fide intention, under circumstances showing the good faith of such person, to use a trademark in commerce, may request registration of its trademark on the principal register hereby established by paying the prescribed fee and filing in the Patent and Trademark Office an application and a verified statement, in such form as may be prescribed by the director. Paragraph 2. The application shall include specification of the applicant's domicile and citizenship, the goods in connection with which the applicant has a bona fide intention to use the mark, and a drawing of the mark. Paragraph 3. The statement shall be verified by the applicant and specify: Subparagraph A. That the person making the verification believes that he or she, or the juristic person in whose behalf he or she makes the verification, to be entitled to use the mark in commerce. Subparagraph B. The applicant's bona fide intention to use the mark in commerce. Subparagraph C. That to the best of the verifier's knowledge and belief, the facts recited in the application are accurate, and Subparagraph D. That to the best of the verifier's knowledge and belief, no other person has the right to use such mark in commerce, either in the identical form thereof, or in such near resemblance thereto as to be likely, when used on or in connection with the goods of such other person, to cause confusion, or to cause mistake, or to deceive. Except for applications filed pursuant to Section 1126 of this title, no mark shall be registered until the applicant has met the requirements of subsections C and D of this section. Paragraph 4. The applicant shall comply with such rules or regulations as may be prescribed by the Director. The Director shall promulgate rules prescribing the requirements for the application and for obtaining a filing date herein. Subsection C. Amendment of application under subsection B to conform to requirements of subsection A. At any time during examination of an application filed under subsection B, an applicant who has made use of the mark in commerce may claim the benefits of such use for purposes of this chapter by amending his or her application to bring it into conformity with the requirements of subsection A. Subsection D. Verified statement that trademark is used in commerce. Paragraph 1. Within 6 months after the date on which the notice of allowance with respect to a mark is issued under Section 1063, subsection B, paragraph 2 of this title to an applicant under subsection B of this section, the applicant shall file in the Patent and Trademark Office, together with such number of specimens or facsimiles of the mark as used in commerce as may be required by the Director in payment of the prescribed fee, a verified statement that the mark is in use in commerce and specifying the date of the applicant's first use of the mark in commerce and those goods or services specified in the notice of allowance on or in connection with which the mark is used in commerce. Subject to examination and acceptance of the statement of use, the mark shall be registered in the Patent and Trademark Office. A certificate of registration shall be issued for those goods or services recited in the statement of use for which the mark is entitled to registration, and notice of registration shall be published in the Official Gazette of the Patent and Trademark Office. Such examination may include an examination of the factors set forth in subsections A through E of Section 1052 of this title. The notice of registration shall specify the goods or services for which the mark is registered. Paragraph 2. The Director shall extend for one additional 6-month period the time for filing the statement of use under paragraph 1 upon written request of the applicant before the expiration of the 6-month period provided in paragraph 1. In addition to an extension under the preceding sentence, the Director may, upon a showing of good cause by the applicant, further extend the time for filing the statement of use under paragraph 1 for periods aggregating not more than 24 months, pursuant to written request of the applicant made before the expiration of the last extension granted under this paragraph. Any request for an extension under this paragraph shall be accompanied by a verified statement that the applicant has a continued bona fide intention to use the mark in commerce and specifying those goods or services identified in the notice of allowance on or in connection with which the applicant has a continued bona fide intention to use the mark in commerce. Any request for an extension under this paragraph shall be accompanied by payment of the prescribed fee. The Director shall issue regulations setting forth guidelines for determining what constitutes good cause for purposes of this paragraph. Paragraph 3. The Director shall notify any applicant who files a statement of use of the acceptance or refusal thereof, and if the statement of use is refused, the reasons for the refusal, and an applicant may amend the statement of use. Paragraph 4. The failure to timely file a verified statement of use under paragraph 1 or an extension request under paragraph 2 shall result in abandonment of the application, unless it can be shown to the satisfaction of the Director that the delay in responding was unintentional, in which case the time for filing may be extended, but for a period not to exceed the period specified in paragraphs 1 and 2 for filing a statement of use. Subsection E. Designation of resident for service of process and notices. If the applicant is not domiciled in the United States, the applicant may designate by a document filed in the United States Patent and Trademark Office the name and address of a person resident in the United States on whom may be served notices or process and proceedings affecting the mark. Such notices or process may be served upon the person so designated by leaving with that person or mailing to that person a copy thereof at the address specified in the last designation so filed. if the person so designated cannot be found at the address given in the last designation, or if the registrant does not designate by a document filed in the United States Patent and Trademark Office the name and address of a person resident in the United States on whom may be served notices or process in proceedings affecting the mark. Such notices or process may be served on the director. Subsection F. Third-party submission of evidence. A third party may submit for consideration for inclusion in the record of an application evidence relevant to a ground for refusal of registration. The third-party submission shall identify the ground for refusal and include a concise description of each piece of evidence submitted in support of each identified ground for refusal. Not later than 2 months after the date on which the submission is filed, the director shall determine whether the evidence should be included in the record of the application. The director shall establish by regulation appropriate procedures for the consideration of evidence submitted by a third party under this subsection and may prescribe a fee to accompany the submission. If the director determines that the third-party evidence should be included in the record of the application, only the evidence and the ground for refusal to which the evidence relates may be so included. Any determination by the director whether or not to include evidence in the record of an application shall be final and non-reviewable, and a determination to include or to not include evidence in the record shall not prejudice any party's right to raise any issue and rely on any evidence in any other proceeding. Section 1052. Trademarks registrable on principal register. Concurrent registration. No trademark by which the goods of the applicant may be distinguished from the goods of others shall be refused registration on the principal register on account of its nature, unless it: Subsection A. Consists of or comprises immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest a connection with persons, living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute, or a geographical indication which, when used on or in connection with wines or spirits, identifies a place other than the origin of the goods and is first used on or in connection with wines or spirits by the applicant on or after 1 year after the date on which the WTO agreement, as defined in Section 3501. Substract 9 of Title 19 enters into force with respect to the United States. Subsection B. Consists of or comprises the flag or coat of arms or other insignia of the United States or of any state or municipality or of any foreign nation or any simulation thereof. Subsection C. Consists of or comprises a name, portrait, or signature identifying a particular living individual except by his written consent, or the name, signature, or portrait of a deceased president of the United States during the life of his widow, except by the written consent of the widow. Subsection D. Consists of or comprises a mark which so resembles a mark registered in the Patent and Trademark Office, or a mark or trade name previously used in the United States by another and not abandoned, as to be likely, when used on or in connection with the goods of the applicant, to cause confusion or to cause mistake or to deceive, provided that if the director determines that confusion, mistake, or deception is not likely to result from the continued use by more than one person of the same or similar marks under conditions and limitations, as to the mode or place of use of the marks or the goods on or in connection with which such marks are used. Concurrent registrations may be issued to such persons when they have become entitled to use such marks as a result of their concurrent lawful use in commerce prior to one the earliest of the filing dates of the applications pending or of any registration issued under this chapter. Paragraph 2. July 5, 1947, in the case of registrations previously issued under the Act of March 3, 1881, or February 20, 1905, and continuing in full force and effect on that date, or 30 July 5, 1947, in the case of applications filed under the Act of February 20, 1905, and registered after July 5, 1947. used prior to the filing date of any pending application or registration shall not be required when the owner of such application or registration consents to the grant of a concurrent registration to the applicant. Concurrent registrations may also be issued by the director when a court of competent jurisdiction has finally determined that more than one person is entitled to use the same or similar marks in commerce. In issuing concurrent registrations, the director shall prescribe conditions and limitations as to the mode or place of use of the mark or the goods on or in connection with which such mark is registered to the respective persons. Subsection E consists of a mark which one, when used on or in connection with the goods of the applicant, is merely descriptive or deceptively misdescriptive of them. Paragraph 2. When used on or in connection with the goods of the applicant is primarily geographically descriptive of them, except as indications of regional origin may be registrable under Section 1054 of this title. Paragraph 3. When used on or in connection with the goods of the applicant is primarily geographically deceptively misdescriptive of them. Paragraph 4 is primarily merely a surname, or 5 comprises any matter that, as a whole, is functional. Subsection F, except as expressly excluded in subsections A, B, C, D, E3, and E5 of this section, nothing in this chapter shall prevent the registration of a mark used by the applicant which has become distinctive of the applicant's goods in commerce. The director may accept as prima facie evidence that the mark has become distinctive as used on or in connection with the applicant's goods in commerce, proof of substantially exclusive and continuous use thereof as a mark by the applicant in commerce for the 5 years before the date on which the claim of distinctiveness is made. Nothing in this section shall prevent the registration of a mark which, when used on or in connection with the goods of the applicant, is primarily geographically deceptively misdescriptive of them, and which became distinctive of the applicant's goods in commerce before December 8, 1993. A mark which would be likely to cause dilution by blurring or dilution by tarnishment under Section 1125, subsection C of this title, may be refused registration only pursuant to a proceeding brought under Section 1063 of this title. A registration for a mark which would be likely to cause dilution by blurring or dilution by tarnishment under Section 1125, subsection C of this title, may be cancelled pursuant to a proceeding brought under either Section 1064 of this title or Section 1092 of this title. Section 1053. Service marks registrable. Subject to the provisions relating to the registration of trademarks, so far as they are applicable, service marks shall be registrable in the same manner and with the same effect as are trademarks, and when registered they shall be entitled to the protection provided in this chapter in the case of trademarks. Applications and procedure under this section shall conform as nearly as practicable to those prescribed for the registration of trademarks. Section 1054. Collective marks and certification marks registrable. Subject to the provisions relating to the registration of trademarks, so far as they are applicable, collective and certification marks, including indications of regional origin, shall be registrable under this chapter, in the same manner and with the same effect as are trademarks by persons in nations, states, municipalities, and the like, exercising legitimate control over the use of the mark sought to be registered, even though not possessing an industrial or commercial establishment, and when registered they shall be entitled to the protection provided in this chapter in the case of trademarks, except in the case of certification marks when used so as to represent falsely that the owner or a user thereof makes or sells the goods or performs the services on or in connection with which such mark is used. Applications and procedure under this section shall conform as nearly as practicable to those prescribed for the registration of trademarks. Section 1055. Use by related companies affecting validity and registration. Where a registered mark or a mark, sought to be registered is or may be used legitimately by related companies. Such use shall inure to the benefit of the registrant or applicant for registration, and such use shall not affect the validity of such mark or of its registration, provided such mark is not used in such manner as to deceive the public. If first use of a mark by a person is controlled by the registrant or applicant for registration of the mark with respect to the nature and quality of the goods or services, such first use shall inure to the benefit of the registrant or applicant, as the case may be. Section 1056. Disclaimer of unregistrable matter. Subsection A. Compulsory and voluntary disclaimers. The director may require the applicant to disclaim an unregistrable component of a mark otherwise registrable. An applicant may voluntarily disclaim a component of a mark sought to be registered. Subsection B. Prejudice of rights. No disclaimer, including those made under subsection E of section 1057 of this title, shall prejudice or affect the applicant's or registrant's rights then existing or thereafter arising in the disclaimed matter, or his right of registration on another application, if the disclaimed matter be or shall have become distinctive of his goods or services. Section 1057. Certificates of registration. Subsection A. Issuance and form. Certificates of registration of marks registered upon the principal register shall be issued in the name of the United States of America under the seal of the United States Patent and Trademark Office, and shall be signed by the director or have his signature placed thereon, and a record thereof shall be kept in the United States Patent and Trademark Office. The registration shall reproduce the mark and state that the mark is registered on the principal register under this chapter, the date of the first use of the mark, in commerce, the particular goods or services for which it is registered, the number and date of the registration, the term thereof, the date on which the application for registration was received in the United States Patent and Trademark Office, and any conditions and limitations that may be imposed in the registration. Subsection B. Certificate as prima facie evidence. A certificate of registration of a mark upon the principal register provided by this chapter shall be prima facie evidence of the validity of the registered mark and of the registration of the mark, of the owner's ownership of the mark, and of the owner's exclusive right to use the registered mark in commerce on or in connection with the goods or services specified in the certificate, subject to any conditions or limitations stated in the certificate. Subsection C. Application to register mark considered constructive use. Contingent on the registration of a mark on the principal register provided by this chapter, the filing of the application to register such mark shall constitute constructive use of the mark, conferring a right of priority nationwide in effect on or in connection with the goods or services specified in the registration against any other person, except for a person whose mark has not been abandoned and who, prior to such filing, Paragraph 1 has used the mark. Paragraph 2 has filed an application to register the mark which is pending or has resulted in registration of the mark, or Paragraph 3 has filed a foreign application to register the mark on the basis of which he or she has acquired a right of priority and timely files an application under Section 1126, substack D of this title, to register the mark which is pending or has resulted in registration of the mark. Subsection D. Issuance to assignee. A certificate of registration of a mark may be issued to the assignee of the applicant, but the assignment must first be recorded in the United States Patent and Trademark Office. In case of change of ownership, the director shall, at the request of the owner and upon a proper showing and the payment of the prescribed fee, issue to such assignee a new certificate of registration of the said mark in the name of such assignee, and for the unexpired part of the original period. Subsection E. Surrender, cancellation, or amendment by owner. Upon application of the owner, the director may permit any registration to be surrendered for cancellation, and upon cancellation, appropriate entry shall be made in the records of the United States Patent and Trademark Office. Upon application of the owner and payment of the prescribed fee, the director for good cause may permit any registration to be amended or to be disclaimed in part, provided that the amendment or disclaimer does not alter materially the character of the mark. Appropriate entry shall be made in the records of the United States Patent and Trademark Office and upon the certificate of registration. Subsection F. Copies of United States Patent and Trademark Office records as evidence. Copies of any records, books, papers, or drawings belonging to the United States Patent and Trademark Office relating to marks, and copies of registrations. When authenticated by the seal of the United States Patent and Trademark Office and certified by the director, or in his name by an employee of the office duly designated by the director, shall be evidence in all cases wherein the originals would be evidence, and any person making application therefor and paying the prescribed fee shall have such copies. Subsection G. Correction of United States Patent and Trademark Office mistake. Whenever a material mistake in a registration incurred through the fault of the United States Patent and Trademark Office is clearly disclosed by the records of the office, a certificate stating the fact and nature of such mistake shall be issued without charge and recorded, and a printed copy thereof shall be attached to each printed copy of the registration, and such corrected registration shall thereafter have the same effect as if the same had been originally issued in such corrected form. Or, in the discretion of the director, a new certificate of registration may be issued without charge. All certificates of correction, heretofore issued in accordance with the rules of the United States Patent and Trademark Office, and the registrations to which they are attached, shall have the same force and effect as if such certificates and their issue had been specifically authorized by statute. Subsection H. Correction of applicant's mistake. Whenever a mistake has been made in a registration and a showing has been made that such mistake occurred in good faith through the fault of the applicant, the director is authorized to issue a certificate of correction or, in his discretion, a new certificate upon the payment of the prescribed fee, provided that the correction does not involve such changes in the registration as to require republication of the mark. Section 1058. Duration, affidavits, and fees. Subsection A. Time periods for required affidavits. Each registration shall remain in force for 10 years, except that the registration of any mark shall be canceled by the director, unless the owner of the registration files in the United States Patent and Trademark Office affidavits that meet the requirements of subsection B within the following time periods. Paragraph 1. Within the 1-year period immediately preceding the expiration of 6 years following the date of registration under this chapter, or the date of the publication under Section 1062, subsection C of this title. Paragraph 2. Within the 1-year period immediately preceding the expiration of 10 years following the date of registration, and each successive 10-year period following the date of registration. Paragraph 3. The owner may file the affidavit required under this section within the 6-month grace period immediately following the expiration of the periods established in paragraphs 1 and 2, together with the fee described in subsection B and the additional grace period surcharge prescribed by the director. Subsection B. Requirements for affidavit. The affidavit referred to in subsection A shall: Paragraph 1. Subparagraph A state that the mark is in use in commerce. Subparagraph B set forth the goods and services recited in the registration on or in connection with which the mark is in use in commerce. Subparagraph C be accompanied by such number of specimens or facsimiles showing current use of the mark in commerce as may be required by the director. And Subparagraph D be accompanied by the fee prescribed by the director, or paragraph 2, subparagraph A, set forth the goods and services recited in the registration on or in connection with which the mark is not in use in commerce. Subparagraph B, include a showing that any non-use is due to special circumstances which excuse such non-use and is not due to any intention to abandon the mark, and subparagraph C be accompanied by the fee prescribed by the director. Subsection C, deficient affidavit. If any submission filed within the period set forth in subsection A is deficient, including that the affidavit was not filed in the name of the owner of the registration, the deficiency may be corrected after the statutory time period, within the time prescribed after notification of the deficiency. Such submission shall be accompanied by the additional deficiency surcharge prescribed by the director. Subsection D, notice of requirement. Special notice of the requirement for such affidavit shall be attached to each certificate of registration and notice of publication under Section 10,062, subsection C of this title. Subsection E, notification of acceptance or refusal. The director shall notify any owner who files any affidavit required by this section of the director's acceptance or refusal thereof, and, in the case of a refusal, the reasons therefor. Subsection F, designation of resident for service of process and notices. If the owner is not domiciled in the United States, the owner may designate by a document filed in the United States Patent and Trademark Office the name and address of a person resident in the United States on whom may be served notices or process and proceedings affecting the mark. Such notices or process may be served upon the person so designated by leaving with that person or mailing to that person a copy thereof at the address specified in the last designation so filed. If the person so designated cannot be found at the last designated address, or if the owner does not designate by a document filed in the United States Patent and Trademark Office the name and address of a person resident in the United States on whom may be served notices or process and proceedings affecting the mark, such notices or process may be served on the director. Section 1059, Renewal of Registration. Subsection A, period of renewal, time for renewal. Subject to the provisions of Section 1058 of this title, each registration may be renewed for periods of 10 years at the end of each successive 10-year period following the date of registration upon payment of the prescribed fee and the filing of a written application in such form as may be prescribed by the director. Such application may be made at any time within 1 year before the end of each successive 10-year period for which the registration was issued or renewed, or it may be made within a grace period of 6 months after the end of each successive 10-year period, upon payment of a fee and surcharge prescribed therefor. If any application filed under this section is deficient, the deficiency may be corrected within the time prescribed after notification of the deficiency, upon payment of a surcharge prescribed therefor. Subsection B, notification of refusal of renewal. If the director refuses to renew the registration, the director shall notify the registrant of the commissioner's refusal and the reasons therefor. Subsection C, designation of resident for service of process and notices. If the registrant is not domiciled in the United States, the registrant may designate by a document filed in the United States Patent and Trademark Office the name and address of a person resident in the United States on whom may be served notices or process in proceedings affecting the mark. Such notices or process may be served upon the person so designated by leaving with that person or mailing to that person a copy thereof at the address specified in the last designation so filed. If the person so designated cannot be found at the address given in the last designation, or if the registrant does not designate by a document filed in the United States Patent and Trademark Office the name and address of a person resident in the United States on whom may be served notices or process in proceedings affecting the mark, such notices or process may be served on the director. Section 1060. Assignment. Subsection A. Paragraph 1. A registered mark or a mark for which an application to register has been filed shall be assignable with the goodwill of the business in which the mark is used, or with that part of the goodwill of the business connected with the use of and symbolized by the mark. Notwithstanding the preceding sentence, no application to register a mark under Section 105(1), subsection B of this title shall be assignable prior to the filing of an amendment under Section 105(1), substack C of this title to bring the application into conformity with Section 105(b)(1), subsection A of this title, or the filing of the verified statement of use under Section 105(1), subsection D of this title, except for an assignment to a successor to the business of the applicant or portion thereof to which the mark pertains, if that business is ongoing and existing. Paragraph 2. In any assignment authorized by this section, it shall not be necessary to include the goodwill of the business connected with the use of and symbolized by any other mark used in the business or by the name or style under which the business is conducted. Paragraph 3. Assignments shall be by instruments in writing duly executed. Acknowledgment shall be prima facie evidence of the execution of an assignment, and when the prescribed information reporting the assignment is recorded in the United States Patent and Trademark Office, the record shall be prima facie evidence of execution. Paragraph 4. An assignment shall be void against any subsequent purchaser for valuable consideration without notice, unless the prescribed information reporting the assignment is recorded in the United States Patent and Trademark Office within 3 months after the date of the assignment or prior to the subsequent purchase. Paragraph 5. The United States Patent and Trademark Office shall maintain a record of information on assignments in such form as may be prescribed by the Director. Subsection B. An assignee not domiciled in the United States may designate by a document filed in the United States Patent and Trademark Office the name and address of a person resident in the United States on whom may be served notices or process in proceedings affecting the mark. Such notices or process may be served upon the person so designated by leaving with that person or mailing to that person a copy thereof at the address specified in the last designation so filed. If the person so designated cannot be found at the address given in the last designation, or if the assignee does not designate by a document filed in the United States Patent and Trademark Office the name and address of a person resident in the United States on whom may be served notices or process in proceedings affecting the mark, such notices or process may be served upon the Director. Section 1061. Execution of acknowledgments and verifications. Acknowledgments and verifications required under this chapter may be made before any person within the United States authorized by law to administer oaths, or, when made in a foreign country, before any diplomatic or consular officer of the United States, or before any official authorized to administer oaths in the foreign country concerned whose authority is proved by a certificate of a diplomatic or consular officer of the United States, or apostille of an official designated by a foreign country which by a treaty or convention accords like effect to apostilles of designated officials in the United States, and shall be valid if they comply with the laws of the state or country where made. Section 1062. Publication. Subsection A. Examination and publication. Upon the filing of an application for registration and payment of the prescribed fee, the Director shall refer the application to the examiner in charge of the registration of marks, who shall cause an examination to be made and, If on such examination it shall appear that the applicant is entitled to registration, or would be entitled to registration upon the acceptance of the statement of use required by Section 1051, subsection D of this title, the Director shall cause the mark to be published in the Official Gazette of the Patent and Trademark Office, provided that in the case of an applicant claiming concurrent use, or in the case of an application to be placed in an interference as provided for in Section 1066 of this title, the mark, if otherwise registrable, may be published subject to the determination of the rights of the parties to such proceedings. Subsection B. Refusal of registration, amendment of application, abandonment, extensions of time to respond. Paragraph 1. If the applicant is found not entitled to registration, the examiner shall notify the applicant thereof and of the reasons therefor. The applicant may reply or amend the application, which shall then be re-examined. This procedure may be repeated until the examiner finally refuses registration of the mark or the application is abandoned, as described in paragraph 2. Paragraph 2. After notification under paragraph 1, the applicant shall have a period of 6 months in which to reply or amend the application, or such shorter time that is not less than 60 days, as prescribed by the Director by regulation. If the applicant fails to reply or amend or appeal within the relevant time period, including any extension under paragraph 3, the application shall be deemed to have been abandoned, unless it can be shown to the satisfaction of the Director that the delay in responding was unintentional, in which case the application may be revived and such time may be extended. The Director may prescribe a fee to accompany any request to revive. Paragraph 3. The Director shall provide by regulation for extensions of time to respond to the examiner for any time period under paragraph 2 that is less than 6 months. The Director shall allow the applicant to obtain extensions of time to reply or amend aggregating 6 months from the date of notification under paragraph 1 when the applicant so requests. However, the Director may set by regulation the time for individual periods of extension and prescribe a fee by regulation for any extension request. Any request for extension shall be filed on or before the date on which a reply or amendment is due under paragraph 1. Subsection C. Republication of marks registered under prior acts. A registrant of a mark registered under the provisions of the Act of March 3, 181, or the Act of February 20, 1905, may, at any time prior to the expiration of the registration thereof, upon the payment of the prescribed fee, file with the Director an affidavit setting forth those goods stated in the registration on which said mark is in use in commerce, and that the registrant claims the benefits of this chapter for said mark. The Director shall publish notice thereof with a reproduction of said mark in the Official Gazette, and notify the registrant of such publication and of the requirement for the affidavit of use or non-use, as provided for in subsection B of section 1058 of this title. Marks published under this subsection shall not be subject to the provisions of section 1063 of this title. Section 1063. Opposition to registration. Subsection A. Any person who believes that he would be damaged by the registration of a mark upon the principal register, including the registration of any mark which would be likely to cause dilution by blurring or dilution by tarnishment under section 1125, Hubsteig C of this title, may, upon payment of the prescribed fee, file an opposition in the Patent and Trademark Office, stating the grounds therefor, within 30 days after the publication under subsection A of section 1062 of this title of the mark sought to be registered. Upon written request prior to the expiration of the 30-day period, the time for filing opposition shall be extended for an additional 30 days, and further extensions of time for filing opposition may be granted by the Director for good cause when requested prior to the expiration of an extension. The Director shall notify the applicant of each extension of the time for filing opposition, and opposition may be amended under such conditions as may be prescribed by the Director. Subsection B. Unless registration is successfully opposed. Paragraph 1. A mark entitled to registration on the principal register based on an application filed under Section 1051, subsection A of this title or pursuant to Section 1126 of this title shall be registered in the Patent and Trademark Office. A certificate of registration shall be issued, and notice of the registration shall be published in the Official Gazette of the Patent and Trademark Office, or Paragraph 2. A notice of allowance shall be issued to the applicant if the applicant applied for registration under Section 1051, subsection B of this title. Section 1064. Cancellation of registration. A petition to cancel a registration of a mark stating the grounds relied upon may, upon payment of the prescribed fee, be filed as follows by any person who believes that he is or will be damaged, including as a result of a likelihood of dilution by blurring or dilution by tarnishment under Section 1125, subsection C of this title, by the registration of a mark on the principal register established by this chapter, or under the Act of March 3, 1881, or the Act of February 20th, 1905. Paragraph 1. Within 5 years from the date of the registration of the mark under this chapter. Paragraph 2. Within 5 years from the date of publication under Section 10,062, subsection C of this title of a mark registered under the Act of March 3, 1881, or the Act of February 20, 1905. Paragraph 3. At any time, if the registered mark becomes the generic name for the goods or services, or a portion thereof, for which it is registered, or is functional, or has been abandoned, or its registration was obtained fraudulently or contrary to the provisions of Section 25.4 of this title, or of subsection A, B, or C of Section 25.2 of this title for a registration under this chapter, or contrary to similar prohibitory provisions of such prior acts for a registration under such acts, or if the registered mark is being used by or with the permission of the registrant so as to misrepresent the source of the goods or services on or in connection with which the mark is used. If the registered mark becomes the generic name for less than all of the goods or services for which it is registered, a petition to cancel the registration for only those goods or services may be filed. A registered mark shall not be deemed to be the generic name of goods or services solely because such mark is also used as a name of or to identify a unique product or service. The primary significance of the registered mark to the relevant public rather than purchaser motivation shall be the test for determining whether the registered mark has become the generic name of goods or services on or in connection with which it has been used. Paragraph 4. At any time, if the mark is registered under the Act of March 3, 1881, or the Act of February 20, 1905, and has not been published under the provisions of subsection C of Section 1062 of this title. Paragraph 5. At any time in the case of a certification mark on the ground that the registrant A does not control or is not able legitimately to exercise control over the use of such mark, or B engages in the production or marketing of any goods or services to which the certification mark is applied, or C permits the use of the certification mark for purposes other than to certify, or D discriminately refuses to certify or to continue to certify the goods or services of any person who maintains the standards or conditions which such mark certifies. Paragraph 6. At any time after the 3-year period following the date of registration, if the registered mark has never been used in commerce on or in connection with some or all of the goods or services recited in the registration, provided that the Federal Trade Commission may apply to cancel on the grounds specified in paragraphs 3 and 5 of this section, any mark registered on the principal register established by this chapter, and the prescribed fee shall not be required. Nothing in paragraph 5 shall be deemed to prohibit the registrant from using its certification mark in advertising or promoting recognition of the certification program or of the goods or services meeting the certification standards of the registrant. Such uses of the certification mark shall not be grounds for cancellation under paragraph 5, so long as the registrant does not itself produce, manufacture, or sell any of the certified goods or services to which its identical certification mark is applied. Nothing in paragraph 6 shall be construed to limit the timing applicable to any other ground for cancellation. A registration under section 1126, subsection E or 1141F of this title shall not be canceled pursuant to paragraph 6 if the registrant demonstrates that any non-use is due to special circumstances that excuse such non-use. Section 1065. Incontestability of right to use mark under certain conditions. Except on a ground for which application to cancel may be filed at any time under paragraphs 3, 5, and 6 of section 1064 of this title, and except to the extent, if any, to which the use of a mark registered on the principal register infringes a valid right acquired under the law of any state or territory by use of a mark or trade name continuing from a date prior to the date of registration. Under this chapter of such registered mark, the right of the owner to use such registered mark in commerce for the goods or services on or in connection with which such registered mark has been in continuous use for 5 consecutive years subsequent to the date of such registration and is still in use in commerce shall be incontestable provided that paragraph 1. There has been no final decision adverse to the owner's claim of ownership of such mark for such goods or services or to the owner's right to register the same or to keep the same on the register. And paragraph 2. There is no proceeding involving said rights pending in the United States Patent and Trademark Office or in a court and not finally disposed of. And paragraph 3. An affidavit is filed with the director within 1 year after the expiration of any such 5-year period setting forth those goods or services stated in the registration on or in connection with which such mark has been in continuous use for such 5 consecutive years and is still in use in commerce, and other matters specified in paragraphs 1 and 2 hereof. And paragraph 4. No incontestable right shall be acquired in a mark which is the generic name for the goods or services or a portion thereof for which it is registered. Subject to the conditions above specified in this section, the incontestable right with reference to a mark registered under this chapter shall apply to a mark registered under the Act of March 3, 1881, or the Act of February 20, 1905, upon the filing of the required affidavit with the director within 1 year after the expiration of any period of 5 consecutive years after the date of publication of a mark under the provisions of subsection C of section 1062 of this title. The director shall notify any registrant who files the above prescribed affidavit of the filing thereof. Section 1066. Interference. Declaration by director. Upon petition showing extraordinary circumstances, the director may declare that an interference exists when application is made for the registration of a mark which so resembles a mark previously registered by another, or for the registration of which another has previously made application, as to be likely when used on or in connection with the goods or services of the applicant to cause confusion or mistake or to deceive. No interference shall be declared between an application and the registration of a mark, the right to the use of which has become incontestable. Section 1066A, ex parte, expungement. Subsection A, petition. Notwithstanding sections 057, subsection B and 1072 of this title, and subsections A and B of section 1115 of this title, any person may file a petition to expunge a registration of a mark on the basis that the mark has never been used in commerce on or in connection with some or all of the goods or services recited in the registration. Subsection B, contents of petition. A petition filed under subsection A, together with any supporting documents, shall, Paragraph 1. Identify the registration that is the subject of the petition. Paragraph 2. Identify each good or service recited in the registration for which it is alleged that the mark has never been used in commerce. Paragraph 3. Include a verified statement that sets forth. Subparagraph A. The elements of the reasonable investigation the petitioner conducted to determine that the mark has never been used in commerce on or in connection with the goods and services identified in the petition. And subparagraph B. Any additional facts that support the allegation that the mark has never been used in commerce on or in connection with the identified goods and services. Paragraph 4. Include any supporting evidence on which the petitioner relies. And Paragraph 5. Be accompanied by the fee prescribed by the director. Subsection C. Initial determination, institution. Paragraph 1. Prima facie case determination, institution, and notification. The director shall, for each good or service identified under subsection B, paragraph 2, determine whether the petition sets forth a prima facie case of the mark having never been used in commerce on or in connection with each such good or service, institute an ex parte expungement proceeding for each good or service for which the director determines that a prima facie case has been set forth, and provide a notice to the registrant and petitioner of the determination of whether or not the proceeding was instituted. Such notice shall include a copy of the petition and any supporting documents and evidence that were included with the petition. Paragraph 2. Reasonable investigation guidance. The director shall promulgate regulations regarding what constitutes a reasonable investigation under subsection B, paragraph 3, and the general types of evidence that could support a prima facie case that a mark has never been used in commerce. But the director shall retain the discretion to determine whether a prima facie case is set out in a particular proceeding. Paragraph 3. Determination by director. Any determination by the director whether or not to institute a proceeding under this section shall be final and non-reviewable, and shall not prejudice any party's right to raise any issue and rely on any evidence in any other proceeding, except as provided in subsection J. Subsection D. Ex parte expungement procedures. The procedures for ex parte expungement shall be the same as the procedures for examination under section 10(2), subsection B of this title, except that the director shall promulgate regulations establishing and governing a proceeding under this section, which may include regulations that Paragraph 1. Set response and extension times particular to this type of proceeding, which notwithstanding section 162, subsection B, paragraph 3 of this title, need not be extendable to 6 months. Paragraph 2. Set limits governing the timing and number of petitions filed for a particular registration or by a particular petitioner or real parties in interest. And Paragraph 3. Define the relation of a proceeding under this section to other proceedings concerning the mark. Subsection E. Registrant's evidence of use. A registrant's documentary evidence of use shall be consistent with when a mark shall be deemed to be in use in commerce under the definition of use in commerce in section 1127 of this title, but shall not be limited in form to that of specimens as provided in section 1051, subsection A of this title. Subsection F. Excusable non-use. During an ex parte expungement proceeding for a mark registered under section 1126, subsection E of this title, or an extension of protection under section 1141F of this title, the registrant may offer evidence showing that any non-use is due to special circumstances that excuse such non-use. In such a case, the examiner shall determine whether the facts and evidence demonstrate excusable non-use and shall not find that the registration should be canceled under subsection G for any good or service for which excusable non-use is demonstrated. Subsection G, examiner's decision, order to cancel. For each good or service for which it is determined that a mark has never been used in commerce, and for which the provisions of subsection F do not apply, the examiner shall find that the registration should be canceled for each such good or service. A mark shall not be found to have never been used in commerce if there is evidence of use in commerce by the registrant that temporally would have supported registration at the time the application was filed or the relevant allegation of use was made, or after registration, but before the petition to expunge was filed under subsection A, or an ex parte expungement proceeding was instituted by the director under subsection H. Unless overturned on review of the examiner's decision, the director shall issue an order canceling the registration in whole or in part, after the time for appeal has expired or any appeal proceeding has terminated. Subsection H, ex parte expungement by the director. Paragraph 1. In general, the director may, on the director's own initiative, institute an ex parte expungement proceeding if the director discovers information that supports a prima facie case of a mark having never been used in commerce on or in connection with any good or service covered by a registration. The director shall promptly notify the registrant of such determination, at which time the ex parte expungement proceeding shall proceed according to the same procedures for ex parte expungement established pursuant to subsection D. If the director determines based on the director's own initiative to institute an expungement proceeding, the director shall transmit or make available the information that formed the basis for that determination as part of the institution notice sent to the registrant. Paragraph 2. Rule of construction. Nothing in this subsection shall be construed to limit any other authority of the director. Subsection I. Time for institution. Paragraph 1. When petition may be filed, ex parte expungement proceeding instituted. A petition for ex parte expungement of a registration under subsection A may be filed, or the director may institute on the director's own initiative an ex parte expungement proceeding of a registration under subsection H at any time following the expiration of 3 years after the date of registration and before the expiration of 10 years following the date of registration. Paragraph 2. Exception. Notwithstanding paragraph 1, for a period of 3 years after December 27, 2020, a petition for expungement of a registration under subsection A may be filed, or the director may institute on the director's own initiative an ex parte expungement proceeding of a registration under subsection H at any time following the expiration of 3 years after the date of registration. Subsection J, limitation on later ex parte expungement proceedings. Paragraph 1. No co-pending proceedings with respect to a particular registration while an ex parte expungement proceeding is pending. No later ex parte expungement proceeding may be instituted with respect to the same goods or services that are the subject of a pending ex parte expungement proceeding. Paragraph 2. Estoppel with respect to a particular registration for goods or services previously subject to an instituted expungement proceeding for which, in that proceeding, it was determined that the registrant had used the mark for particular goods or services as relevant, and the registration was not canceled as to those goods or services. No further ex parte expungement proceedings may be initiated as to those goods or services, regardless of the identity of the petitioner. Subsection K, use in commerce requirement not altered. Nothing in this section shall affect the requirement for use in commerce of a mark registered under section 2051, subsection A or 1091 of this title. Section 1066B, ex parte reexamination. Subsection A, petition for reexamination. Any person may file a petition to re-examine a registration of a mark on the basis that the mark was not in use in commerce on or in connection with some or all of the goods or services recited in the registration on or before the relevant date. Subsection B, relevant date. In this section, the term relevant date means with respect to an application for the registration of a mark with an initial filing basis of Paragraph 1, Section 1051, subsection A of this title, and not amended at any point to be filed pursuant to Section 1051, subsection B of this title, the date on which the application was initially filed, or Paragraph 2, Section 1051, subsection B of this title, or amended at any point to be filed pursuant to Section 1051, subsection B of this title, the date on which Subparagraph A, an amendment to allege use under Section 1051, subsection C of this title was filed, or Subparagraph B, the period for filing a statement of use under Section 1051, subsection D of this title expired, including all approved extensions thereof. Subsection C, requirements for the petition. A petition filed under subsection A together with any supporting documents shall: Paragraph 1. Identify the registration that is the subject of the petition. Paragraph 2. Identify each good and service recited in the registration for which it is alleged that the mark was not in use in commerce on or in connection with on or before the relevant date. Paragraph 3. Include a verified statement that sets forth: Subparagraph A, the elements of the reasonable investigation the petitioner conducted to determine that the mark was not in use in commerce on or in connection with the goods and services identified in the petition on or before the relevant date, and Subparagraph B, any additional facts that support the allegation that the mark was not in use in commerce on or before the relevant date on or in connection with the identified goods and services. Paragraph 4 includes supporting evidence on which the petitioner relies, and Paragraph 5 be accompanied by the fee prescribed by the director. Subsection D, initial determination, institution. Paragraph 1. Prima facie case determination, institution, and notification. The director shall, for each good or service identified under subsection C, paragraph 2, determine whether the petition sets forth a prima facie case of the mark having not been in use in commerce on or in connection with each such good or service. Institute an ex parte reexamination proceeding for each good or service for which the director determines that the prima facie case has been set forth, and provide a notice to the registrant and petitioner of the determination of whether or not the proceeding was instituted. Such notice shall include a copy of the petition and any supporting documents and evidence that were included with the petition. Paragraph 2. Reasonable investigation guidance. The director shall promulgate regulations regarding what constitutes a reasonable investigation under subsection C. Paragraph 3. And the general types of evidence that could support a prima facie case that the mark was not in use in commerce on or in connection with a good or service on or before the relevant date, but the director shall retain discretion to determine whether a prima facie case is set out in a particular proceeding. Paragraph 3. Determination by director. Any determination by the director whether or not to institute a re-examination proceeding under this section shall be final and non-reviewable, and shall not prejudice any party's right to raise any issue and rely on any evidence in any other proceeding, except as provided in subsection J. Subsection E, re-examination procedures. The procedures for re-examination shall be the same as the procedures established under Section 10,006-2, subsection B of this title, except that the director shall promulgate regulations establishing and governing a proceeding under this section, which may include regulations that: Paragraph 1. set response and extension times particular to this type of proceeding, which, notwithstanding Section 1062, subsection B, paragraph 3 of this title, need not be extendable to 6 months. Paragraph 2. Set limits governing the timing and number of petitions filed for a particular registration or by a particular petitioner or real parties in interest. And paragraph 3. Define the relation of a reexamination proceeding under this section to other proceedings concerning the mark. Subsection F. Registrant's evidence of use. A registrant's documentary evidence of use shall be consistent with when a mark shall be deemed to be in use in commerce under the definition of use in commerce in Section 1027 of this title, but shall not be limited in form to that of specimens as provided in Section 1051, subsection A of this title. Subsection G. Examiner's decision order to cancel. For each good or service for which it is determined that the registration should not have issued because the mark was not in use in commerce on or before the relevant date, the examiner shall find that the registration should be canceled for each such good or service. Unless overturned on review of the examiner's decision, the director shall issue an order canceling the registration in whole or in part after the time for appeal has expired or any appeal proceeding has terminated. Subsection H. Reexamination by director. Paragraph 1. In general, the director may, on the director's own initiative, institute an ex parte reexamination proceeding if the director discovers information that supports a prima facie case of the mark having not been used in commerce on, or in connection with some or all of the goods or services covered by the registration on or before the relevant date. The director shall promptly notify the registrant of such determination, at which time reexamination shall proceed according to the same procedures established pursuant to subsection E. If the director determines based on the director's own initiative to institute an ex parte reexamination proceeding, the director shall transmit or make available the information that formed the basis for that determination as part of the institution notice. Paragraph 2. Rule of construction. Nothing in this subsection shall be construed to limit any other authority of the director. Subsection I. Time for institution. A petition for ex parte reexamination may be filed, or the director may institute on the director's own initiative an ex parte reexamination proceeding at any time not later than 5 years after the date of registration of a mark registered based on use in commerce. Subsection J. Limitation on later ex parte reexamination proceedings. Paragraph 1. No co-pending proceedings. With respect to a particular registration, while an ex parte reexamination proceeding is pending, no later ex parte reexamination proceeding may be instituted with respect to the same goods or services that are the subject of a pending ex parte reexamination proceeding. Paragraph 2. Estoppel. With respect to a particular registration for any goods or services previously subject to an instituted ex parte reexamination proceeding for which, in that proceeding, it was determined that the registrant had used the mark for particular goods or services before the relevant date, and the registration was not canceled as to those goods or services. No further ex parte reexamination proceedings may be initiated as to those goods or services regardless of the identity of the petitioner. Subsection K. Supplemental Register. The provisions of subsection B apply as appropriate to registrations under Section 10,091 of this title. Nothing in this section shall be construed to limit the timing of a cancellation action under Section 10,092 of this title. Section 1067. Interference, opposition, and proceedings for concurrent use registration or for cancellation. Notice, trademark trial, and appeal board. Subsection A. In every case of interference, opposition to registration, application to register as a lawful concurrent user, or application to cancel the registration of a mark. The director shall give notice to all parties and shall direct a trademark trial and appeal board to determine and decide the respective rights of registration. Subsection B. The Trademark Trial and Appeal Board shall include the Director, Deputy Director of the United States Patent and Trademark Office, the Commissioner for Patents, the Commissioner for Trademarks, and administrative trademark judges who are appointed by the Secretary of Commerce in consultation with the Director. Subsection C. Authority of the Secretary. The Secretary of Commerce may, in his or her discretion, deem the appointment of an administrative trademark judge who, before August 12, 2008, held office pursuant to an appointment by the Director to take effect on the date on which the Director initially appointed the administrative trademark judge. Subsection D. Defense to challenge of appointment. It shall be a defense to a challenge to the appointment of an administrative trademark judge on the basis of the judges having been originally appointed by the Director that the administrative trademark judge so appointed was acting as a de facto officer. Section 1068. Action of Director and interference, opposition, and proceedings for concurrent use registration or for cancellation. In such proceedings, the Director may refuse to register the opposed mark, may cancel the registration in whole or in part, may modify the application or registration by limiting the goods or services specified therein, may otherwise restrict or rectify with respect to the registration of a registered mark, may refuse to register any or all of several interfering marks, or may register the mark or marks for the person or persons entitled thereto, as the rights of the parties under this chapter may be established in the proceedings. The authority of the Director under this section includes the authority to reconsider and modify or set aside a decision of the Trademark Trial and Appeal Board, provided that in the case of the registration of any mark based on concurrent use, the Director shall determine and fix the conditions and limitations provided for in subsection D of section 1052 of this title. However, no final judgment shall be entered in favor of an applicant under section 1051, subsection B of this title before the mark is registered, if such applicant cannot prevail without establishing constructive use pursuant to section 1057, substract C of this title. Section 1069. Application of equitable principles in inter partes proceedings. In all inter partes proceedings, equitable principles of laches, estoppel, and acquiescence, where applicable, may be considered and applied. Section 1070. Appeals to trademark trial and appeal board from decisions of examiners. An appeal may be taken to the trademark trial and appeal board from any final decision of the examiner in charge of the registration of marks, or a final decision by an examiner in an ex parte expungement proceeding or ex parte reexamination proceeding upon the payment of the prescribed fee. The Director may reconsider and modify or set aside a decision of the trademark trial and appeal board under this section. Section 1071. Appeal to courts. Subsection A. Persons entitled to appeal. United States Court of Appeals for the Federal Circuit. Waiver of civil action. Election of civil action by adverse party procedure. Paragraph 1. An applicant for registration of a mark, party to an interference proceeding, party to an opposition proceeding, party to an application to register as a lawful concurrent user, party to a cancellation proceeding. A registrant who has filed an affidavit as provided in Section 1058 of this title or Section 1141K of this title, an applicant for renewal, or a registrant subject to an ex parte expungement proceeding or an ex parte reexamination proceeding, who is dissatisfied with the decision of the director or trademark trial and appeal board may appeal to the United States Court of Appeals for the Federal Circuit, thereby waiving his right to proceed under subsection B of this section, provided that such appeal shall be dismissed if any adverse party to the proceeding, other than the director, shall, within 20 days after the appellant has filed notice of appeal according to paragraph 2 of this subsection, files notice with the director that he elects to have all further proceedings conducted as provided in subsection B of this section. Thereupon the appellant shall have 30 days thereafter within which to file a civil action under subsection B of this section, in default of which the decision appealed from shall govern the further proceedings in the case. Paragraph 2. When an appeal is taken to the United States Court of Appeals for the Federal Circuit, the appellant shall file in the United States Patent and Trademark Office a written notice of appeal directed to the director, within such time after the date of the decision from which the appeal is taken as the director prescribes, but in no case less than 60 days after that date. Paragraph 3. The director shall transmit to the United States Court of Appeals for the Federal Circuit a certified list of the documents comprising the record in the United States Patent and Trademark Office. The court may request that the director forward the original or certified copies of such documents during pendency of the appeal. In an ex parte case, the director shall submit to that court a brief explaining the grounds for the decision of the United States Patent and Trademark Office, addressing all the issues involved in the appeal. The court shall, before hearing an appeal, give notice of the time and place of the hearing to the director and the parties in the appeal. Paragraph 4. The United States Court of Appeals for the Federal Circuit shall review the decision from which the appeal is taken on the record before the United States Patent and Trademark Office. Upon its determination, the court shall issue its mandate and opinion to the director, which shall be entered of record in the United States Patent and Trademark Office and shall govern the further proceedings in the case. However, no final judgment shall be entered in favor of an applicant under Section 10,051, subsection B of this title before the mark is registered, if such applicant cannot prevail without establishing constructive use pursuant to Section 10,057. Subsection C of this title. Subsection B, civil action, persons entitled to jurisdiction of court, status of director, procedure. Paragraph 1. Whenever a person authorized by subsection A of this section to appeal to the United States Court of Appeals for the Federal Circuit, except for a registrant subject to an ex parte expungement proceeding or an ex parte reexamination proceeding, is dissatisfied with the decision of the director or trademark trial and appeal board, said person may, unless appeal has been taken to said United States Court of Appeals for the Federal Circuit, have remedy by a civil action if commenced within such time after such decision, not less than 60 days as the director appoints or as provided in subsection A of this section. The court may adjudge that an applicant is entitled to a registration upon the application involved, that a registration involved should be canceled, or such other matter as the issues in the proceeding require, as the facts in the case may appear. Such adjudication shall authorize the director to take any necessary action upon compliance with the requirements of law. However, no final judgment shall be entered in favor of an applicant under Section 1051, subsection B of this title before the mark is registered, if such applicant cannot prevail without establishing constructive use pursuant to Section 1057. Sub C of this title. Paragraph 2. The director shall not be made a party to an inter partes proceeding under this subsection, but he shall be notified of the filing of the complaint by the clerk of the court in which it is filed and shall have the right to intervene in the action. Paragraph 3. In any case where there is no adverse party, a copy of the complaint shall be served on the director, and unless the court finds the expenses to be unreasonable, all the expenses of the proceedings shall be paid by the party bringing the case, whether the final decision is in favor of such party or not. In suits brought hereunder, the record in the United States Patent and Trademark Office shall be admitted on motion of any party, upon such terms and conditions as to costs, expenses, and the further cross-examination of the witnesses as the court imposes, without prejudice to the right of any party to take further testimony. The testimony and exhibits of the record in the United States Patent and Trademark Office, when admitted, shall have the same effect as if originally taken and produced in the suit. Paragraph 4. Where there is an adverse party, such suit may be instituted against the party in interest, as shown by the records of the United States Patent and Trademark Office at the time of the decision complained of, but any party in interest may become a party to the action. If there are adverse parties residing in a plurality of districts not embraced within the same state, or an adverse party residing in a foreign country, the United States District Court for the Eastern District of Virginia shall have jurisdiction and may issue summons against the adverse parties directed to the marshal of any district in which any adverse party resides. Summons against adverse parties residing in foreign countries may be served by publication or otherwise as the court directs. Section 1072. Registration as constructive notice of claim of ownership. Registration of a mark on the principal register provided by this chapter or under the Act of March 3, 1881, or the Act of February 20, 1905, shall be constructive notice of the registrant's claim of ownership thereof. Section 1091. Supplemental Register. Subsection A. Marks registrable. In addition to the principal register, the director shall keep a continuation of the register provided in paragraph B of Section 1 of the Act of March 19, 1920, entitled An Act to Give Effect to Certain Provisions of the Convention for the Protection of Trademarks and Commercial Names, made and signed in the city of Buenos Aires, in the Argentine Republic, August 20, 1910, and for other purposes, to be called the Supplemental Register. All marks capable of distinguishing applicants' goods or services and not registrable on the principal register provided in this chapter, except those declared to be unregistrable under subsections A, B, C, D, and E3 of section 1052 of this title, which are in lawful use in commerce by the owner thereof, on or in connection with any goods or services, may be registered on the supplemental register upon the payment of the prescribed fee in compliance with the provisions of subsections A and E of section 1051 of this title so far as they are applicable. Nothing in this section shall prevent the registration on the supplemental register of a mark capable of distinguishing the applicant's goods or services and not registrable on the principal register under this chapter. That is declared to be unregistrable under section 1052, subsection E, paragraph 3 of this title, if such mark has been in lawful use in commerce by the owner thereof, on or in connection with any goods or services, since before December 8, 1993. Subsection B, application and proceedings for registration. Upon the filing of an application for registration on the supplemental register and payment of the prescribed fee, the director shall refer the application to the examiner in charge of the registration of marks, who shall cause an examination to be made, and if on such examination it shall appear that the applicant is entitled to registration, the registration shall be granted. If the applicant is found not entitled to registration, the provisions of subsection B of section 1062 of this title shall apply. Subsection C, nature of mark. For the purposes of registration on the supplemental register, a mark may consist of any trademark symbol, label, package, configuration of goods, name, word, slogan, phrase, surname, geographical name, numeral device. Any matter that as a whole is not functional, or any combination of any of the foregoing, but such mark must be capable of distinguishing the applicant's goods or services. Section 1092. Publication, not subject to opposition, cancellation. Marks for the supplemental register shall not be published for or be subject to opposition, but shall be published on registration in the official gazette of the Patent and Trademark Office. Whenever any person believes that such person is or will be damaged by the registration of a mark on the supplemental register. Paragraph 1, for which the effective filing date is after the date on which such person's mark became famous, and which would be likely to cause dilution by blurring or dilution by tarnishment under Section 1125, subsection C of this title, or Paragraph 2, on grounds other than dilution by blurring or dilution by tarnishment, such person may at any time, upon payment of the prescribed fee and the filing of a petition stating the ground therefore apply to the director to cancel such registration. The director shall refer such application to the Trademark Trial and Appeal Board, which shall give notice thereof to the registrant. If it is found after a hearing before the board that the registrant is not entitled to registration, or that the mark has been abandoned, the registration shall be canceled by the director unless the director reconsiders the decision of the board and modifies or sets aside such decision. However, no final judgment shall be entered in favor of an applicant under Section 1051, subsection B of this title before the mark is registered, if such applicant cannot prevail without establishing constructive use pursuant to Section 1057, substract C of this title. Section 1093. Registration certificates for marks on principal and supplemental registers to be different. The certificates of registration for marks registered on the supplemental register shall be conspicuously different from certificates issued for marks registered on the principal register. Section 1094. Provisions of chapter applicable to registrations on supplemental register. The provisions of this chapter shall govern so far as applicable applications for registration and registrations on the supplemental register, as well as those on the principal register. But applications for and registrations on the supplemental register shall not be subject to or receive the advantages of sections 1051, subsection B, 1052, subsection E, 1052, subsection F, 1056, subsection B, 1056, subsection C, 1062, subsection A, 1063 to 1068, inclusive 1072, 1115, and 1124 of this title. Registrations on the supplemental register shall be subject to ex parte expungement and ex parte reexamination under sections 1066A and 1066B of this title, respectively. Section 1095. Registration on principal register not precluded. Registration of a mark on the supplemental register, or under the Act of March 19, 1920, shall not preclude registration by the registrant on the principal register established by this chapter. Registration of a mark on the supplemental register shall not constitute an admission that the mark has not acquired distinctiveness. Section 1096. Registration on supplemental register not used to stop importations. Registration on the supplemental register, or under the Act of March 19, 1920, shall not be filed in the Department of the Treasury or be used to stop importations. Section 1111. Notice of registration, display with mark, recovery of profits, and damages in infringement suit. Notwithstanding the provisions of Section 1072 of this title, a registrant of a mark registered in the Patent and Trademark Office may give notice that his mark is registered by displaying with the mark the words "registered in U.S." Patent and Trademark Office, or Reg US. Pat and TM off, or the letter R enclosed within a circle. Thus, and in any suit for infringement under this chapter by such a registrant failing to give such notice of registration, no profits and no damages shall be recovered under the provisions of this chapter unless the defendant had actual notice of the registration. Section 1112, classification of goods and services, registration and plurality of classes. The director may establish a classification of goods and services for convenience of Patent and Trademark Office administration, but not to limit or extend the applicant's or registrant's rights. The applicant may apply to register a mark for any or all of the goods or services on or in connection with which he or she is using or has a bona fide intention to use the mark in commerce, provided that if the director by regulation permits the filing of an application for the registration of a mark for goods or services which fall within a plurality of classes, a fee equaling the sum of the fees for filing an application in each class shall be paid, and the director may issue a single certificate of registration for such mark. Section 1113. Fees. Subsection A. Applications, services, materials. The director shall establish fees for the filing and processing of an application for the registration of a trademark or other mark, and for all other services performed by and materials furnished by the Patent and Trademark Office related to trademarks and other marks. Fees established under this subsection may be adjusted by the director once each year to reflect, in the aggregate, any fluctuations during the preceding 12 months in the Consumer Price Index, as determined by the Secretary of Labor. Changes of less than 1% may be ignored. No fee established under this section shall take effect until at least 30 days after notice of the fee has been published in the Federal Register and in the Official Gazette of the Patent and Trademark Office. Subsection B. Waiver. Indian products. The director may waive the payment of any fee for any service or material related to trademarks or other marks in connection with an occasional request made by a department or agency of the government or any officer thereof. The Indian Arts and Crafts Board will not be charged any fee to register government trademarks of genuineness and quality for Indian products or for products of particular Indian tribes and groups. Section 1114. Remedies, infringement, innocent infringement by printers and publishers. Paragraph 1. Any person who shall, without the consent of the registrant. Subsection A. Use in commerce, any reproduction, counterfeit, copy, or colorable imitation of a registered mark in connection with the sale, offering for sale, distribution, or advertising of any goods or services on or in connection with which such use is likely to cause confusion, or to cause mistake, or to deceive, or. Subsection B. Reproduce, counterfeit, copy, or colorably imitate a registered mark and apply such reproduction, counterfeit, copy, or colorable imitation to labels, signs, prints, packages, wrappers, receptacles, or advertisements intended to be used in commerce upon or in connection with the sale, offering for sale, distribution, or advertising of goods or services on or in connection with which such use is likely to cause confusion or to cause mistake, or to deceive, shall be liable in a civil action by the registrant for the remedies hereinafter provided. Under subsection B hereof, the registrant shall not be entitled to recover profits or damages unless the acts have been committed with knowledge that such imitation is intended to be used to cause confusion, or to cause mistake, or to deceive. As used in this paragraph, the term any person includes the United States, all agencies and instrumentalities thereof, and all individuals, firms, corporations, or other persons acting for the United States and with the authorization and consent of the United States, and any state, any instrumentality of a state, and any officer or employee of a state or instrumentality of a state acting in his or her official capacity. The United States, all agencies and instrumentalities thereof, and all individuals, firms, corporations, other persons acting for the United States, and with the authorization and consent of the United States, and any state, and any such instrumentality, officer, or employee, shall be subject to the provisions of this chapter in the same manner and to the same extent as any non-governmental entity. Paragraph 2. Notwithstanding any other provision of this chapter, the remedies given to the owner of a right infringed under this chapter or to a person bringing an action under Section 1125, subsection A or D of this title shall be limited as follows. Subparagraph A. Where an infringer or violator is engaged solely in the business of printing the mark or violating matter for others and establishes that he or she was an innocent infringer or innocent violator, the owner of the right infringed or person bringing the action under Section 1125, subsection A of this title shall be entitled as against such infringer or violator only to an injunction against future printing. Subparagraph B. Where the infringement or violation complained of is contained in or is part of paid advertising matter in a newspaper, magazine, or other similar periodical or in an electronic communication as defined in Section 2510, subsection 12 of Title 18. The remedies of the owner of the right infringed or person bringing the action under Section 1125, subsection A of this title as against the publisher or distributor of such newspaper, magazine, or other similar periodical or electronic communication shall be limited to an injunction against the presentation of such advertising matter in future issues of such newspapers, magazines, or other similar periodicals, or in future transmissions of such electronic communications. The limitations of this subparagraph shall apply only to innocent infringers and innocent violators. Subparagraph C. Injunctive relief shall not be available to the owner of the right infringed or person bringing the action under Section 1025, subsection A of this title with respect to an issue of a newspaper, magazine, or other similar periodical or an electronic communication containing infringing matter or violating matter where restraining the dissemination of such infringing matter or violating matter in any particular issue of such periodical or in an electronic communication would delay the delivery of such issue or transmission of such electronic communication after the regular time for such delivery or transmission, and such delay would be due to the method by which publication and distribution of such periodical or transmission of such electronic communication is customarily conducted in accordance with sound business practice, and not due to any method or device adopted to evade this section or to prevent or delay the issuance of an injunction or restraining order with respect to such infringing matter or violating matter. Subparagraph D, Clause 1, Subclause 1. A domain name registrar, a domain name registry, or other domain name registration authority that takes any action described under Clause 2 affecting a domain name shall not be liable for monetary relief, or, except as provided in Subclause 2, for injunctive relief to any person for such action, regardless of whether the domain name is finally determined to infringe or dilute the mark. Subclause 2. A domain name registrar, domain name registry, or other domain name registration authority described in Subclause 1 may be subject to injunctive relief only if such registrar, registry, or other registration authority has. Item AA. Not expeditiously deposited with a court in which an action has been filed regarding the disposition of the domain name. Documents sufficient for the court to establish the court's control and authority regarding the disposition of the registration and use of the domain name. Item BB. Transferred, suspended, or otherwise modified the domain name during the pendency of the action, except upon order of the court, or Item CC. Willfully failed to comply with any such court order. Clause 2. An action referred to under Clause 1, Subclause 1 is any action of refusing to register, removing from registration, transferring, temporarily disabling, or permanently canceling a domain name. Subclause 1. In compliance with a court order under Section 1125, subsection D of this title, or Subclause 2. In the implementation of a reasonable policy by such registrar, registry, or authority prohibiting the registration of a domain name that is identical to confusingly similar to, or dilutive of another's mark. Clause 3. A domain name registrar, a domain name registry, or other domain name registration authority shall not be liable for damages under this section for the registration or maintenance of a domain name for another absent a showing of bad faith intent to profit from such registration or maintenance of the domain. Clause 4. If a registrar, registry, or other registration authority takes an action described under Clause 2 based on a knowing and material misrepresentation by any other person that a domain name is identical to, confusingly similar to, or dilutive of a mark, the person making the knowing and material misrepresentation shall be liable for any damages, including costs and attorney's fees incurred by the domain name registrant as a result of such action. The court may also grant injunctive relief to the domain name registrant, including the reactivation of the domain name or the transfer of the domain name to the domain name registrant. Clause 5. A domain name registrant whose domain name has been suspended, disabled, or transferred under a policy described under Clause 2. Subclause 2 may, upon notice to the mark owner, file a civil action to establish that the registration or use of the domain name by such registrant is not unlawful under this chapter. The court may grant injunctive relief to the domain name registrant, including the reactivation of the domain name or transfer of the domain name to the domain name registrant. Subparagraph E, as used in this paragraph. Clause 1. The term violator means a person who violates Section 1125, subsection A of this title, and Clause 2. The term violating matter means matter that is the subject of a violation under Section 1125, subsection A of this title. Paragraph 3. Subparagraph A. Any person who engages in the conduct described in paragraph 11 of Section 110 of Title 17 and who complies with the requirements set forth in that paragraph is not liable on account of such conduct for a violation of any right under this chapter. This subparagraph does not preclude liability, nor shall it be construed to restrict the defenses or limitations on rights granted under this chapter of a person for conduct not described in paragraph 11 of Section 110 of Title 17, even if that person also engages in conduct described in paragraph 11 of Section 110 of such title. Subparagraph B. A manufacturer, licensee, or licensor of technology that enables the making of limited portions of audio or video content of a motion picture imperceptible, as described in subparagraph A, is not liable on account of such manufacture or license for a violation of any right under this chapter. If such manufacturer, licensee, or licensor ensures that the technology provides a clear and conspicuous notice at the beginning of each performance that the performance of the motion picture is altered from the performance intended by the director or copyright holder of the motion picture. The limitations on liability in subparagraph A and this subparagraph shall not apply to a manufacturer, licensee, or licensor of technology that fails to comply with this paragraph. Subparagraph C, the requirement under subparagraph B to provide notice shall apply only with respect to technology manufactured after the end of the 180-day period, beginning on April 27, 2005. Subparagraph D, any failure by a manufacturer, licensee, or licensor of technology to qualify for the exemption under subparagraphs A and B shall not be construed to create an inference that any such party that engages in conduct described in paragraph 11 of Section 110 of Title 17 is liable for trademark infringement by reason of such conduct. Section 1115. Registration on principal register as evidence of exclusive right to use mark. Defenses. Subsection A, evidentiary value. Defenses. Any registration issued under the Act of March 3, 1881, or the Act of February 20, 1905, or of a mark registered on the principal register provided by this chapter and owned by a party to an action, shall be admissible in evidence and shall be prima facie evidence of the validity of the registered mark and of the registration of the mark, of the registrant's ownership of the mark, and of the registrant's exclusive right to use the registered mark in commerce on or in connection with the goods or services specified in the registration, subject to any conditions or limitations stated therein, but shall not preclude another person from proving any legal or equitable defense or defect, including those set forth in subsection B, which might have been asserted if such mark had not been registered. Subsection B. Incontestability. Defenses. To the extent that the right to use the registered mark has become incontestable under Section 1065 of this title, the registration shall be conclusive evidence of the validity of the registered mark and of the registration of the mark, of the registrant's ownership of the mark, and of the registrant's exclusive right to use the registered mark in commerce. Such conclusive evidence shall relate to the exclusive right to use the mark on or in connection with the goods or services specified in the affidavit filed under the provisions of Section 1065 of this title, or in the renewal application filed under the provisions of Section 1059 of this title, if the goods or services specified in the renewal are fewer in number, subject to any conditions or limitations in the registration or in such affidavit or renewal application. Such conclusive evidence of the right to use the registered mark shall be subject to proof of infringement as defined in Section 1114 of this title, and shall be subject to the following defenses or defects. Paragraph 1. That the registration or the incontestable right to use the mark was obtained fraudulently, or Paragraph 2. That the mark has been abandoned by the registrant, or Paragraph 3. That the registered mark is being used by or with the permission of the registrant or a person in privity with the registrant, so as to misrepresent the source of the goods or services on or in connection with which the mark is used, or Paragraph 4. That the use of the name, term, or device charged to be an infringement is a use, otherwise than as a mark, of the party's individual name in his own business, or of the individual name of anyone in privity with such party, or of a term or device which is descriptive of and used fairly and in good faith only to describe the goods or services of such party, or their geographic origin, or Paragraph 5. That the mark whose use by a party is charged as an infringement was adopted without knowledge of the registrant's prior use and has been continuously used by such party or those in privity with him from a date prior to a. the date of constructive use of the mark established pursuant to Section 1057. Substack C of this title, subparagraph B. The registration of the mark under this chapter, if the application for registration is filed before the effective date of the Trademark Law Revision Act of 1988, or C. publication of the registered mark under subsection C of Section 1022 of this title. Provided, however, that this defense or defect shall apply only for the area in which such continuous prior use is proved, or Paragraph 6. That the mark whose use is charged as an infringement was registered and used prior to the registration under this chapter or publication under subsection C of Section 1062 of this title of the registered mark of the registrant and not abandoned. Provided, however, that this defense or defect shall apply only for the area in which the mark was used prior to such registration or such publication of the registrant's mark, or Paragraph 7. That the mark has been or is being used to violate the antitrust laws of the United States, or Paragraph 8. That the mark is functional, or Paragraph 9. That equitable principles including laches, estoppel, and acquiescence are applicable. Section 1116. Injunctive relief. Subsection A. Jurisdiction, service. The several courts vested with jurisdiction of civil actions arising under this chapter shall have power to grant injunctions according to the principles of equity and upon such terms as the court may deem reasonable, to prevent the violation of any right of the registrant of a mark registered in the Patent and Trademark Office, or to prevent a violation under subsection A, C, or D of section 1125 of this title. A plaintiff seeking any such injunction shall be entitled to a rebuttable presumption of irreparable harm upon a finding of a violation identified in this subsection in the case of a motion for a permanent injunction, or upon a finding of likelihood of success on the merits for a violation identified in this subsection in the case of a motion for a preliminary injunction or temporary restraining order. Any such injunction may include a provision directing the defendant to file with the court and serve on the plaintiff within 30 days after the service on the defendant of such injunction or such extended period as the court may direct. A report in writing under oath setting forth in detail the manner and form in which the defendant has complied with the injunction. Any such injunction granted upon hearing after notice to the defendant by any district court of the United States may be served on the parties against whom such injunction is granted anywhere in the United States where they may be found, and shall be operative and may be enforced by proceedings to punish for contempt or otherwise by the court by which such injunction was granted, or by any other United States district court in whose jurisdiction the defendant may be found. Subsection B. Transfer of certified copies of court papers. The said court shall have jurisdiction to enforce said injunction, as provided in this chapter, as fully as if the injunction had been granted by the district court in which it is sought to be enforced. The clerk of the court or judge granting the injunction shall, when required to do so by the court before which application to enforce said injunction is made, transfer without delay to said court a certified copy of all papers on file in his office upon which said injunction was granted. Subsection C. Notice to Director. It shall be the duty of the clerks of such courts within 1 month after the filing of any action, suit, or proceeding involving a mark registered under the provisions of this chapter to give notice thereof in writing to the director, setting forth, in order so far as known, the names and addresses of the litigants and the designating number or numbers of the registration or registrations upon which the action, suit, or proceeding has been brought, and in the event any other registration be subsequently included in the action, suit, or proceeding by amendment, answer, or other pleading, the clerk shall give like notice thereof to the director. And within 1 month after the judgment is entered or an appeal is taken, the clerk of the court shall give notice thereof to the director. And it shall be the duty of the director on receipt of such notice forthwith to endorse the same upon the file wrapper of the said registration or registrations, and to incorporate the same as a part of the contents of said file wrapper. Subsection D. Civil actions arising out of use of counterfeit marks. Paragraph 1. Subparagraph A. In the case of a civil action arising under Section 1114, Subsection 1, Paragraph A, of this title or Section 20506 of Title 36 with respect to a violation that consists of using a counterfeit mark in connection with the sale, offering for sale, or distribution of goods or services, the court may, upon ex parte application, grant an order under subsection A of this section pursuant to this subsection, providing for the seizure of goods and counterfeit marks involved in such violation, and the means of making such marks and records documenting the manufacture, sale, or receipt of things involved in such violation. Subparagraph B. As used in this subsection, the term counterfeit mark means: Clause 1. A counterfeit of a mark that is registered on the principal register in the United States Patent and Trademark Office for such goods or services sold, offered for sale, or distributed, and that is in use. Whether or not the person against whom relief is sought knew such mark was so registered, or Clause 2. A spurious designation that is identical with or substantially indistinguishable from a designation as to which the remedies of this chapter are made available by reason of Section 220506 of Title 36. but such term does not include any mark or designation used on or in connection with goods or services of which the manufacturer or producer was, at the time of the manufacture or production in question, authorized to use the mark or designation for the type of goods or services so manufactured or produced, by the holder of the right to use such mark or designation. Paragraph 2. The court shall not receive an application under this subsection unless the applicant has given such notice of the application as is reasonable under the circumstances to the United States Attorney for the judicial district in which such order is sought. Such attorney may participate in the proceedings arising under such application if such proceedings may affect evidence of an offense against the United States. The court may deny such application if the court determines that the public interest in a potential prosecution so requires. Paragraph 3. The application for an order under this subsection shall, subparagraph A, be based on an affidavit or the verified complaint establishing facts sufficient to support the findings of fact and conclusions of law required for such order, and subparagraph B, contain the additional information required by paragraph 5 of this subsection to be set forth in such order. Paragraph 4. The court shall not grant such an application unless, subparagraph A, the person obtaining an order under this subsection provides the security determined adequate by the court for the payment of such damages as any person may be entitled to recover as a result of a wrongful seizure or wrongful attempted seizure under this subsection. And subparagraph B, the court finds that it clearly appears from specific facts that Clause 1. An order other than an ex parte seizure order is not adequate to achieve the purposes of Section 1114 of this title. Clause 2. The applicant has not publicized the requested seizure. Clause 3. The applicant is likely to succeed in showing that the person against whom seizure would be ordered used a counterfeit mark in connection with the sale, offering for sale or distribution of goods or services. Clause 4. An immediate and irreparable injury will occur if such seizure is not ordered. Clause 5. The matter to be seized will be located at the place identified in the application. Clause 6. The harm to the applicant of denying the application outweighs the harm to the legitimate interests of the person against whom seizure would be ordered of granting the application. And Clause 7. The person against whom seizure would be ordered, or persons acting in concert with such person, would destroy, move, hide, or otherwise make such matter inaccessible to the court if the applicant were to proceed on notice to such person. Paragraph 5. An order under this subsection shall set forth. Subparagraph A. The findings of fact and conclusions of law required for the order. Subparagraph B, a particular description of the matter to be seized and a description of each place at which such matter is to be seized. Subparagraph C, the time period, which shall end not later than 7 days after the date on which such order is issued, during which the seizure is to be made. Subparagraph D, the amount of security required to be provided under this subsection, and subparagraph E, a date for the hearing required under paragraph 10 of this subsection. Paragraph 6. The court shall take appropriate action to protect the person against whom an order under this subsection is directed from publicity by or at the behest of the plaintiff about such order and any seizure under such order. Paragraph 7. Any materials seized under this subsection shall be taken into the custody of the court. For seizures made under this section, the court shall enter an appropriate protective order with respect to discovery and use of any records or information that has been seized. The protective order shall provide for appropriate procedures to ensure that confidential, private, proprietary, or privileged information contained in such records is not improperly disclosed or used. Paragraph 8. An order under this subsection, together with the supporting documents, shall be sealed until the person against whom the order is directed has an opportunity to contest such order, except that any person against whom such order is issued shall have access to such order and supporting documents after the seizure has been carried out. Paragraph 9. The court shall order that service of a copy of the order under this subsection shall be made by a federal law enforcement officer, such as a United States Marshal, or an officer or agent of the United States Customs Service, Secret Service, Federal Bureau of Investigation, or Post Office, or may be made by a state or local law enforcement officer who, upon making service, shall carry out the seizure under the order. The court shall issue orders, when appropriate, to protect the defendant from undue damage from the disclosure of trade secrets or other confidential information during the course of the seizure, including, when appropriate, orders restricting the access of the applicant or any agent or employee of the applicant to such secrets or information. Paragraph 10. Subparagraph A. The court shall hold a hearing unless waived by all the parties on the date set by the court in the order of seizure. That date shall be not sooner than 10 days after the order is issued and not later than 15 days after the order is issued, unless the applicant for the order shows good cause for another date, or unless the party against whom such order is directed consents to another date for such hearing. At such hearing, the party obtaining the order shall have the burden to prove that the facts supporting findings of fact and conclusions of law necessary to support such order are still in effect. If that party fails to meet that burden, the seizure order shall be dissolved or modified appropriately. Subparagraph B. In connection with a hearing under this paragraph, the court may make such orders modifying the time limits for discovery under the rules of civil procedure as may be necessary to prevent the frustration of the purposes of such hearing. Paragraph 11. A person who suffers damage by reason of a wrongful seizure under this subsection has a cause of action against the applicant for the order under which such seizure was made and shall be entitled to recover such relief as may be appropriate, including damages for lost profits, cost of materials, loss of goodwill, and punitive damages in instances where the seizure was sought in bad faith, and, unless the court finds extenuating circumstances, to recover a reasonable attorney's fee. The court, in its discretion, may award prejudgment interest on relief recovered under this paragraph at an annual interest rate established under Section 6621, subsection A, paragraph 2 of Title 26. Commencing on the date of service of the claimant's pleading setting forth the claim under this paragraph, and ending on the date such recovery is granted, or for such shorter time as the court deems appropriate. Section 1117. Recovery for violation of rights. Subsection A. Profits, damages and costs, attorney fees. When a violation of any right of the registrant of a mark registered in the Patent and Trademark Office, a violation under Section 1125, subsection A or D of this title, or a willful violation under Section 1125, subsection C of this title, shall have been established in any civil action arising under this chapter, the plaintiff shall be entitled, subject to the provisions of Sections 1011-11 and 1114 of this title, and subject to the principles of equity, to recover one defendant's profits. Paragraph 2. Any damages sustained by the plaintiff, and 3. The costs of the action. The court shall assess such profits and damages or cause the same to be assessed under its direction. In assessing profits, the plaintiff shall be required to prove defendant's sales only. Defendant must prove all elements of cost or deduction claimed. In assessing damages, the court may enter judgment according to the circumstances of the case for any sum above the amount found as actual damages, not exceeding 3 times such amount. If the court shall find that the amount of the recovery based on profits is either inadequate or excessive, the court may in its discretion enter judgment for such sum as the court shall find to be just according to the circumstances of the case. Such sum in either of the above circumstances shall constitute compensation and not a penalty. The court in exceptional cases may award reasonable attorney fees to the prevailing party. Subsection B. Treble damages for use of counterfeit mark. In assessing damages under subsection A for any violation of section 1114, subsection 1, paragraph A of this title or section 220506 of Title 36, in a case involving use of a counterfeit mark or designation, as defined in section 1116, Hubstock D of this title, the court shall, unless the court finds extenuating circumstances, enter judgment for 3 times such profits or damages, whichever amount is greater, together with a reasonable attorney's fee, if the violation consists of: Paragraph 1. Intentionally using a mark or designation, knowing such mark or designation is a counterfeit mark, as defined in section 1116, subsection D of this title, in connection with the sale, offering for sale, or distribution of goods or services, or Paragraph 2, providing goods or services necessary to the commission of a violation specified in paragraph 1, with the intent that the recipient of the goods or services would put the goods or services to use in committing the violation. In such a case, the court may award prejudgment interest on such amount at an annual interest rate established under Section 6621, subsection A, paragraph 2 of Title 26, beginning on the date of the service of the claimant's pleadings, setting forth the claim for such entry of judgment, and ending on the date such entry is made, or for such shorter time as the court considers appropriate. Subsection C. Statutory damages for use of counterfeit marks. In a case involving the use of a counterfeit mark, as defined in section 1116, subsection D of this title, in connection with the sale, offering for sale, or distribution of goods or services, the plaintiff may elect, at any time before final judgment is rendered by the trial court, to recover, instead of actual damages and profits under subsection A, an award of statutory damages for any such use in connection with the sale, offering for sale, or distribution of goods or services in the amount of Paragraph 1. Not less than $1,000 or more than $200,000 per counterfeit mark per type of goods or services sold, offered for sale, or distributed as the court considers just, or Paragraph 2. If the court finds that the use of the counterfeit mark was willful, not more than $2 million per counterfeit mark per type of goods or services sold, offered for sale, or distributed as the court considers just. Subsection D. Statutory damages for violation of Section 1045, subsection D, paragraph 1. In a case involving a violation of Section 1025, subsection D, paragraph 1 of this title, the plaintiff may elect, at any time before final judgment is rendered by the trial court, to recover, instead of actual damages and profits, an award of statutory damages in the amount of not less than $1,000 and not more than $100,000 per domain name, as the court considers just. Subsection E. Rebuttable presumption of willful violation. In the case of a violation referred to in this section, it shall be a rebuttable presumption that the violation is willful for purposes of determining relief if the violator, or a person acting in concert with the violator, knowingly provided or knowingly caused to be provided materially false contact information to a domain name registrar, domain name registry, or other domain name registration authority in registering, maintaining, or renewing a domain name used in connection with the violation. Nothing in this subsection limits what may be considered a willful violation under this section. Section 1118. Destruction of infringing articles. In any action arising under this chapter, in which a violation of any right of the registrant of a mark registered in the Patent and Trademark Office, a violation under Section 1125, subsection A of this title, or a willful violation under Section 1125, Substack C of this title shall have been established. The court may order that all labels, signs, prints, packages, wrappers, receptacles, and advertisements in the possession of the defendant bearing the registered mark or, in the case of a violation of Section 1025, subsection A of this title, or a willful violation under Section 1125, subsection C of this title, the word, term, name, symbol, device, combination thereof, designation, description, or representation, that is the subject of the violation or any reproduction, counterfeit copy or colorable imitation thereof, and all plates, molds, matrices, and other means of making the same shall be delivered up and destroyed. The party seeking an order under this section for destruction of articles seized under Section 1116. Subtract D of this title shall give 10 days' notice to the United States Attorney for the judicial district in which such order is sought, unless good cause is shown for lesser notice, and such United States Attorney may, if such destruction may affect evidence of an offense against the United States, seek a hearing on such destruction or participate in any hearing otherwise to be held with respect to such destruction. Section 1119. Power of court over registration. In any action involving a registered mark, the court may determine the right to registration, order the cancellation of registrations in whole or in part, restore canceled registrations, and otherwise rectify the register with respect to the registrations of any party to the action. Decrees and orders shall be certified by the court to the director, who shall make appropriate entry upon the records of the Patent and Trademark Office and shall be controlled thereby. Section 1120. Civil liability for false or fraudulent registration. Any person who shall procure registration in the Patent and Trademark Office of a mark by a false or fraudulent declaration or representation, oral or in writing, or by any false means, shall be liable in a civil action by any person injured thereby for any damages sustained in consequence thereof. Section 1121. Jurisdiction of federal courts. State and local requirements that registered trademarks be altered or displayed differently. Prohibition. Subsection A. The district and territorial courts of the United States shall have original jurisdiction, and the courts of appeal of the United States, other than the United States Court of Appeals for the Federal Circuit, shall have appellate jurisdiction of all actions arising under this chapter, without regard to the amount in controversy or to diversity or lack of diversity of the citizenship of the parties. Subsection B. No state or other jurisdiction of the United States or any political subdivision or any agency thereof may require alteration of a registered mark or require that additional trademarks, service marks, trade names, or corporate names that may be associated with or incorporated into the registered mark be displayed in the mark in a manner differing from the display of such additional trademarks, service marks, trade names, or corporate names contemplated by the registered mark as exhibited in the certificate of registration issued by the United States Patent and Trademark Office. Section 1121A. Transferred. Section 1122. Liability of United States and states and instrumentalities and officials thereof. Subsection A. Waiver of sovereign immunity by the United States. The United States, all agencies and instrumentalities thereof, and all individuals, firms, corporations, other persons acting for the United States, and with the authorization and consent of the United States, shall not be immune from suit in federal or state court by any person, including any governmental or non-governmental entity, for any violation under this chapter. Subsection B. Waiver of sovereign immunity by states. Any state, instrumentality of a state, or any officer or employee of a state, or instrumentality of a state acting in his or her official capacity shall not be immune, under the 11th Amendment of the Constitution of the United States or under any other doctrine of sovereign immunity from suit in federal court by any person, including any governmental or non-governmental entity for any violation under this chapter. Subsection C. Remedies. In a suit described in subsection A or B for a violation described therein. Remedies, including remedies both at law and in equity, are available for the violation to the same extent. As such, remedies are available for such a violation in a suit against any person other than the United States or any agency or instrumentality thereof, or any individual, firm, corporation, or other person acting for the United States and with authorization and consent of the United States, or a state, instrumentality of a state, or officer or employee of a state, or instrumentality of a state acting in his or her official capacity. Such remedies include injunctive relief under Section 1116 of this title, actual damages, profits, costs, and attorney's fees under Section 1117 of this title, destruction of infringing articles under Section 1118 of this title. The remedies provided for under Sections 1 to 1114, 1 to 9, 1 to 4, and 125 of this title, and for any other remedies provided under this chapter. Section 1123, Rules and Regulations for Conduct of Proceedings in Patent and Trademark Office. The Director shall make rules and regulations not inconsistent with law for the conduct of proceedings in the Patent and Trademark Office under this chapter. Section 1124, Importation of goods bearing infringing marks or names forbidden. Except as provided in subsection D of Section 1526 of Title 19, no article of imported merchandise which shall copy or simulate the name of any domestic manufacturer or trader, or of any manufacturer or trader located in any foreign country which by treaty, convention, or law affords similar privileges to citizens of the United States, or which shall copy or simulate a trademark registered in accordance with the provisions of this chapter, or shall bear a name or mark calculated to induce the public to believe that the article is manufactured in the United States, or that it is manufactured in any foreign country or locality other than the country or locality in which it is in fact manufactured, shall be admitted to entry at any custom house of the United States, and, in order to aid the officers of the customs in enforcing this prohibition, any domestic manufacturer or trader, and any foreign manufacturer or trader who is entitled under the provisions of a treaty, convention, declaration, or agreement between the United States and any foreign country to the advantages afforded by law to citizens of the United States in respect to trademarks and commercial names may require his name and residence, and the name of the locality in which his goods are manufactured, and a copy of the certificate of registration of his trademark issued in accordance with the provisions of this chapter, to be recorded in books which shall be kept for this purpose in the Department of the Treasury, under such regulations as the Secretary of the Treasury shall prescribe, and may furnish to the Department facsimiles of his name, the name of the locality in which his goods are manufactured or of his registered trademark, and thereupon the Secretary of the Treasury shall cause one or more copies of the same to be transmitted to each collector or other proper officer of customs. Section 1125. False designations of origin, false descriptions, and dilution forbidden. Subsection A. Civil action. Paragraph 1. Any person who, on or in connection with any goods or services or any container for goods, uses in commerce any word, term, name, symbol, or device, or any combination thereof, or any false designation of origin, false or misleading description of fact, or false or misleading representation of fact, which, subparagraph A, is likely to cause confusion or to cause mistake or to deceive as to the affiliation, connection, or association of such person with another person, or as to the origin, sponsorship, or approval of his or her goods, services, or commercial activities by another person, or subparagraph B, in commercial advertising or promotion, misrepresents the nature, characteristics, qualities, or geographic origin of his or her or another person's goods, services, or commercial activities, shall be liable in a civil action by any person who believes that he or she is or is likely to be damaged by such act. Paragraph 2. As used in this subsection, the term any person includes any state, instrumentality of a state, or employee of a state, or instrumentality of a state acting in his or her official capacity. Any state and any such instrumentality, officer, or employee shall be subject to the provisions of this chapter in the same manner and to the same extent as any non-governmental entity. Paragraph 3. In a civil action for trade dress infringement under this chapter for trade dress not registered on the principal register, the person who asserts trade dress protection has the burden of proving that the matter sought to be protected is not functional. Subsection B. Importation. Any goods marked or labeled in contravention of the provisions of this section shall not be imported into the United States or admitted to entry at any custom house of the United States. The owner, importer, or consignee of goods refused entry at any custom house under this section may have any recourse by protest or appeal that is given under the customs revenue laws, or may have the remedy given by this chapter in cases involving goods refused entry or seized. Subsection C. Dilution by blurring, dilution by tarnishment. Paragraph 1. Injunctive relief. Subject to the principles of equity, the owner of a famous mark that is distinctive inherently or through acquired distinctiveness shall be entitled to an injunction against another person who at any time after the owner's mark has become famous commences use of a mark or trade name in commerce that is likely to cause dilution by blurring or dilution by tarnishment of the famous mark, regardless of the presence or absence of actual or likely confusion, of competition, or of actual economic injury. Paragraph 2. Definitions. Subparagraph A. For purposes of paragraph 1, a mark is famous if it is widely recognized by the general consuming public of the United States as a designation of source of the goods or services of the mark's owner. In determining whether a mark possesses the requisite degree of recognition, the court may consider all relevant factors, including the following. Clause 1. The duration, extent, and geographic reach of advertising and publicity of the mark, whether advertised or publicized by the owner or third parties. Clause 2. The amount, volume, and geographic extent of sales of goods or services offered under the mark. Clause 3. The extent of actual recognition of the mark. Clause 4. Whether the mark was registered under the Act of March 3, 1881 or the Act of February 20, 1905 or on the principal register. Subparagraph B. For purposes of paragraph 1, dilution by blurring is association arising from the similarity between a mark or trade name and a famous mark that impairs the distinctiveness of the famous mark. In determining whether a mark or trade name is likely to cause dilution by blurring, the court may consider all relevant factors, including the following. Clause 1. The degree of similarity between the mark or trade name and the famous mark. Clause 2. The degree of inherent or acquired distinctiveness of the famous mark. Clause 3. The extent to which the owner of the famous mark is engaging in substantially exclusive use of the mark. Clause 4. The degree of recognition of the famous mark. Clause 5. Whether the user of the mark or trade name intended to create an association with the famous mark. Clause 6. Any actual association between the mark or trade name and the famous mark. Subparagraph C. For purposes of paragraph 1, dilution by tarnishment is association arising from the similarity between a mark or trade name and a famous mark that harms the reputation of the famous mark. Paragraph 3. Exclusions. The following shall not be actionable as dilution by blurring or dilution by tarnishment under this subsection. Subparagraph A. Any fair use, including a nominative or descriptive fair use or facilitation of such fair use, of a famous mark by another person other than as a designation of source for the person's own goods or services, including use in connection with. Clause 1. Advertising or promotion that permits consumers to compare goods or services, or Clause 2. Identifying and parodying, criticizing, or commenting upon the famous mark owner or the goods or services of the famous mark owner. Subparagraph B. All forms of news reporting and news commentary. Subparagraph C. Any non-commercial use of a mark. Paragraph 4. Burden of proof. In a civil action for trade dress dilution under this chapter for trade dress not registered on the principal register, the person who asserts trade dress protection has the burden of proving that Subparagraph A. The claimed trade dress, taken as a whole, is not functional and is famous, and Subparagraph B. If the claimed trade dress includes any mark or marks registered on the principal register, the unregistered matter, taken as a whole, is famous separate and apart from any fame of such registered marks. Paragraph 5. Additional remedies. In an action brought under this subsection, the owner of the famous mark shall be entitled to injunctive relief as set forth in section 11(1)(16) of this title. The owner of the famous mark shall also be entitled to the remedies set forth in sections 1117, subsection A, and 1008 of this title, subject to the discretion of the court and the principles of equity if Subparagraph A. The mark or trade name that is likely to cause dilution by blurring or dilution by tarnishment was first used in commerce by the person against whom the injunction is sought after October 6, 2006, and Subparagraph B. In a claim arising under this subsection. Clause 1. By reason of dilution by blurring, the person against whom the injunction is sought willfully intended to trade on the recognition of the famous mark, or Clause 2. By reason of dilution by tarnishment, the person against whom the injunction is sought willfully intended to harm the reputation of the famous mark. Paragraph 6. Ownership of valid registration, a complete bar to action. The ownership by a person of a valid registration under the Act of March 3, 1881, or the Act of February 20, 1905, or on the principal register under this chapter shall be a complete bar to an action against that person with respect to that mark, that Subparagraph A is brought by another person under the common law or a statute of a state, and Subparagraph B. Clause 1 seeks to prevent dilution by blurring or dilution by tarnishment, or Clause 2 asserts any claim of actual or likely damage or harm to the distinctiveness or reputation of a mark, label, or form of advertisement. Paragraph 7. Savings Clause. Nothing in this subsection shall be construed to impair, modify, or supersede the applicability of the patent laws of the United States. Subsection D. Cyber piracy prevention. Paragraph 1. Subparagraph A. A person shall be liable in a civil action by the owner of a mark, including a personal name, which is protected as a mark under this section, if, without regard to the goods or services of the parties, that person. Clause 1 has a bad faith intent to profit from that mark, including a personal name which is protected as a mark under this section, and Clause 2 registers, traffics in, or uses a domain name that. Subclause 1, in the case of a mark that is distinctive at the time of registration of the domain name, is identical or confusingly similar to that mark. Subclause 2. In the case of a famous mark that is famous at the time of registration of the domain name, is identical or confusingly similar to or dilutive of that mark, or Subclause 3. is a trademark word or name protected by reason of Section 706 of Title 18 or Section 20, 2005-06 of Title 36. Subparagraph B, Clause 1. In determining whether a person has a bad faith intent described under subparagraph A, a court may consider factors such as, but not limited to, Subclause 1, the trademark or other intellectual property rights of the person, if any, in the domain name. Subclause 2, the extent to which the domain name consists of the legal name of the person or a name that is otherwise commonly used to identify that person. Subclause 3, the person's prior use, if any, of the domain name in connection with the bona fide offering of any goods or services. Subclause 4, the person's bona fide non-commercial or fair use of the mark in a site accessible under the domain name. Subclause 5, the person's intent to divert consumers from the mark owner's online location to a site accessible under the domain name that could harm the goodwill represented by the mark, either for commercial gain or with the intent to tarnish or disparage the mark, by creating a likelihood of confusion as to the source, sponsorship, affiliation, or endorsement of the site. Subclause 6, the person's offer to transfer, sell, or otherwise assign the domain name to the mark owner or any third party for financial gain without having used or having an intent to use the domain name in the bona fide offering of any goods or services, or the person's prior conduct indicating a pattern of such conduct. Subclause 7, the person's provision of material and misleading false contact information when applying for the registration of the domain name, the person's intentional failure to maintain accurate contact information, or the person's prior conduct indicating a pattern of such conduct. Subclause 8, the person's registration or acquisition of multiple domain names which the person knows are identical or confusingly similar to marks of others that are distinctive at the time of registration of such domain names, or dilutive of famous marks of others that are famous at the time of registration of such domain names, without regard to the goods or services of the parties. And Subclause 9, the extent to which the mark incorporated in the person's domain name registration is or is not distinctive and famous within the meaning of subsection C. Clause 2, bad faith intent described under subparagraph A shall not be found in any case in which the court determines that the person believed and had reasonable grounds to believe that the use of the domain name was a fair use or otherwise lawful. Subparagraph C, in any civil action involving the registration, trafficking, or use of a domain name under this paragraph, a court may order the forfeiture or cancellation of the domain name or the transfer of the domain name to the owner of the mark. Subparagraph D, a person shall be liable for using a domain name under subparagraph A only if that person is the domain name registrant or that registrant's authorized licensee. Subparagraph E, as used in this paragraph, the term traffics in refers to transactions that include, but are not limited to, sales, purchases, loans, pledges, licenses, exchanges of currency, and any other transfer for consideration or receipt in exchange for consideration. Paragraph 2, subparagraph A, the owner of a mark may file an in rem civil action against a domain name in the judicial district in which the domain name registrar, domain name registry, or other domain name authority that registered or assigned the domain name is located if Clause 1, the domain name violates any right of the owner of a mark registered in the Patent and Trademark Office or protected under subsection A or C, and Clause 2, the court finds that the owner. Subclause 1 is not able to obtain in personam jurisdiction over a person who would have been a defendant in a civil action under paragraph 1, or Subclause 2, through due diligence was not able to find a person who would have been a defendant in a civil action under paragraph 1 by Item AA, sending a notice of the alleged violation, an intent to proceed under this paragraph to the registrant of the domain name at the postal and email address provided by the registrant to the registrar. And item B, publishing notice of the action as the court may direct promptly after filing the action. Subparagraph B, the actions under subparagraph A, clause 2 shall constitute service of process. Subparagraph C, in an in rem action under this paragraph, a domain name shall be deemed to have its situs in the judicial district in which clause 1, the domain name, registrar, registry, or other domain name authority that registered or assigned the domain name is located. Or clause 2, documents sufficient to establish control and authority regarding the disposition of the registration and use of the domain name are deposited with the court. Subparagraph D, clause 1, the remedies in an in rem action under this paragraph shall be limited to a court order for the forfeiture or cancellation of the domain name or the transfer of the domain name to the owner of the mark. Upon receipt of written notification of a filed, stamped copy of a complaint filed by the owner of a mark in a United States District Court under this paragraph, the domain name registrar, domain name registry, or other domain name authority shall, subclause 1, expeditiously deposit with the court documents sufficient to establish the court's control and authority regarding the disposition of the registration and use of the domain name to the court, and subclause 2, not transfer, suspend, or otherwise modify the domain name during the pendency of the action except upon order of the court. Clause 2, the domain name registrar or registry or other domain name authority shall not be liable for injunctive or monetary relief under this paragraph except in the case of bad faith or reckless disregard, which includes a willful failure to comply with any such court order. Paragraph 3. The civil action established under paragraph 1 and the in rem action established under paragraph 2 and any remedy available under either such action shall be in addition to any other civil action or remedy otherwise applicable. Paragraph 4. The in rem jurisdiction established under paragraph 2 shall be in addition to any other jurisdiction that otherwise exists, whether in rem or in personam. Section 1126, International Conventions. Subsection A, Register of Marks communicated by international bureaus. The director shall keep a register of all marks communicated to him by the international bureaus provided for by the Conventions for the Protection of Industrial Property, Trademarks, Trade and Commercial Names, and the Repression of Unfair Competition to which the United States is or may become a party, and upon the payment of the fees required by such conventions, and the fees required in this chapter may place the marks so communicated upon such register. This register shall show a facsimile of the mark or trade or commercial name, the name, citizenship, and address of the registrant, the number, date, and place of the first registration of the mark, including the dates on which application for such registration was filed and granted, and the term of such registration. A list of goods or services to which the mark is applied as shown by the registration in the country of origin, and such other data as may be useful concerning the mark. This register shall be a continuation of the register provided in Section 1, subsection A of the Act of March 19, 1920. Subsection B, benefits of section to persons whose country of origin is party to convention or treaty. Any person whose country of origin is a party to any convention or treaty relating to trademarks, trade, or commercial names, or the repression of unfair competition, to which the United States is also a party, or extends reciprocal rights to nationals of the United States by law, shall be entitled to the benefits of this section under the conditions expressed herein to the extent necessary to give effect to any provision of such convention, treaty, or reciprocal law, in addition to the rights to which any owner of a mark is otherwise entitled by this chapter. Subsection C, prior registration in country of origin defined. No registration of a mark in the United States by a person described in subsection B of this section shall be granted until such mark has been registered in the country of origin of the applicant, unless the applicant alleges use in commerce. For the purposes of this section, the country of origin of the applicant is the country in which he has a bona fide and effective industrial or commercial establishment, or if he has not such an establishment, the country in which he is domiciled. Or if he has not a domicile in any of the countries described in subsection B of this section, the country of which he is a national. Subsection D, right of priority. An application for registration of a mark under section 1051, 1053, 1054, or 1091 of this title, or under subsection E of this section, filed by a person described in subsection B of this section who has previously duly filed an application for registration of the same mark in one of the countries described in subsection B shall be accorded the same force and effect as would be accorded to the same application if filed in the United States on the same date on which the application was first filed in such foreign country, provided that paragraph 1. The application in the United States is filed within 6 months from the date on which the application was first filed in the foreign country. Paragraph 2. The application conforms as nearly as practicable to the requirements of this chapter, including a statement that the applicant has a bona fide intention to use the mark in commerce. Paragraph 3. The rights acquired by third parties before the date of the filing of the first application in the foreign country shall in no way be affected by a registration obtained on an application filed under this subsection. Paragraph 4. Nothing in this subsection shall entitle the owner of a registration granted under this section to sue for acts committed prior to the date on which his mark was registered in this country, unless the registration is based on use in commerce. In like manner and subject to the same conditions and requirements, the right provided in this section may be based upon a subsequent regularly filed application in the same foreign country, instead of the first filed foreign application, provided that any foreign application filed prior to such subsequent application has been withdrawn, abandoned, or otherwise disposed of without having been laid open to public inspection and without leaving any rights outstanding, and has not served, nor thereafter shall serve as a basis for claiming a right of priority. Subsection E, registration on principal or supplemental register, copy of foreign registration. A mark duly registered in the country of origin of the foreign applicant may be registered on the principal register if eligible, otherwise on the supplemental register in this chapter provided. Such applicant shall submit, within such time period as may be prescribed by the director, a true copy, a photocopy, a certification, or a certified copy of the registration in the country of origin of the applicant. The application must state the applicant's bona fide intention to use the mark in commerce, but use in commerce shall not be required prior to registration. Subsection F, domestic registration independent of foreign registration. The registration of a mark under the provisions of subsections C, D, and E of this section by a person described in subsection B shall be independent of the registration in the country of origin, and the duration, validity, or transfer in the United States of such registration shall be governed by the provisions of this chapter. Subsection G, trade or commercial names of foreign nationals protected without registration. Trade names or commercial names of persons described in subsection B of this section shall be protected without the obligation of filing a registration, whether or not they form parts of marks. Subsection H, protection of foreign nationals against unfair competition. Any person designated in subsection B of this section as entitled to the benefits and subject to the provisions of this chapter shall be entitled to effective protection against unfair competition, and the remedies provided in this chapter for infringement of marks shall be available so far as they may be appropriate in repressing acts of unfair competition. Subsection I. Citizens or residents of United States entitled to benefits of section. Citizens or residents of the United States shall have the same benefits as are granted by this section to persons described in subsection B of this section. Section 1127. Construction and definitions. Intent of chapter. In the construction of this chapter, unless the contrary is plainly apparent from the context, the United States includes and embraces all territory which is under its jurisdiction and control. The word commerce means all commerce which may lawfully be regulated by Congress. The term principal register refers to the register provided for by sections 1051 to 1072 of this title, and the term supplemental register refers to the register provided for by sections 1091 to 1096 of this title. The term person and any other word or term used to designate the applicant or other entitled to a benefit or privilege or rendered liable under the provisions of this chapter includes a juristic person as well as a natural person. The term juristic person includes a firm, corporation, union, association, or other organization capable of suing and being sued in a court of law. The term person also includes the United States, any agency or instrumentality thereof, or any individual, firm, or corporation acting for the United States and with the authorization and consent of the United States. The United States, any agency or instrumentality thereof, and any individual, firm, or corporation acting for the United States and with the authorization and consent of the United States, shall be subject to the provisions of this chapter in the same manner and to the same extent as any non-governmental entity. The term person also includes any state, any instrumentality of a state, and any officer or employee of a state or instrumentality of a state acting in his or her official capacity. Any state and any such instrumentality, officer, or employee shall be subject to the provisions of this chapter in the same manner and to the same extent as any non-governmental entity. The terms applicant and registrant embrace the legal representatives, predecessors, successors, and assigns of such applicant or registrant. The term director means the Undersecretary of Commerce for Intellectual Property and Director of the United States Patent and Trademark Office. The term related company means any person whose use of a mark is controlled by the owner of the mark, with respect to the nature and quality of the goods or services on or in connection with which the mark is used. The terms trade name and commercial name mean any name used by a person to identify his or her business or vocation. The term trademark includes any word, name, symbol, or device, or any combination thereof. Paragraph 1. Used by a person, or Paragraph 2, which a person has a bona fide intention to use in commerce and applies to register on the principal register established by this chapter. To identify and distinguish his or her goods, including a unique product, from those manufactured or sold by others, and to indicate the source of the goods even if that source is unknown. The term service mark means any word, name, symbol, or device, or any combination thereof. Paragraph 1, used by a person, or Paragraph 2, which a person has a bona fide intention to use in commerce and applies to register on the principal register established by this chapter. To identify and distinguish the services of one person, including a unique service from the services of others, and to indicate the source of the services, even if that source is unknown. Titles, character names, and other distinctive features of radio or television programs may be registered as service marks, notwithstanding that they, or the programs, may advertise the goods of the sponsor. The term certification mark means any word, name, symbol, or device, or any combination thereof. Paragraph 1, used by a person other than its owner, or Paragraph 2, which its owner has a bona fide intention to permit a person other than the owner to use in commerce and files an application to register on the principal register established by this chapter. To certify regional or other origin, material, mode of manufacture, quality, accuracy, or other characteristics of such person's goods or services, or that the work or labor on the goods or services was performed by members of a union or other organization. The term collective mark means a trademark or service mark. Paragraph 1, used by the members of a cooperative, an association, or other collective group or organization, or Paragraph 2, which such cooperative, association, or other collective group or organization has a bona fide intention to use in commerce and applies to register on the principal register established by this chapter, and includes marks indicating membership in a union, an association, or other organization. The term mark includes any trademark, service mark, collective mark, or certification mark. The term use in commerce means the bona fide use of a mark in the ordinary course of trade, and not made merely to reserve a right in a mark. For purposes of this chapter, a mark shall be deemed to be in use in commerce. Paragraph 1, on goods when, subparagraph A, it is placed in any manner on the goods or their containers or the displays associated therewith, or on the tags or labels affixed thereto, or if the nature of the goods makes such placement impracticable, then on documents associated with the goods or their sale, and subparagraph B, the goods are sold or transported in commerce, and paragraph 2, on services when it is used or displayed in the sale or advertising of services, and the services are rendered in commerce, or the services are rendered in more than one state or in the United States and a foreign country, and the person rendering the services is engaged in commerce in connection with the services. A mark shall be deemed to be abandoned if either of the following occurs. Paragraph 1. When its use has been discontinued with intent not to resume such use. Intent not to resume may be inferred from circumstances. Non-use for 3 consecutive years shall be prima facie evidence of abandonment. Use of a mark means the bona fide use of such mark made in the ordinary course of trade, and not made merely to reserve a right in a mark. Paragraph 2. When any course of conduct of the owner, including acts of omission as well as commission, causes the mark to become the generic name for the goods or services on or in connection with which it is used, or otherwise to lose its significance as a mark. Purchaser motivation shall not be a test for determining abandonment under this paragraph. The term colorable imitation includes any mark which so resembles a registered mark as to be likely to cause confusion or mistake, or to deceive. The term registered mark means a mark registered in the United States Patent and Trademark Office under this chapter, or under the Act of March 3, 1881, or the Act of February 20, 1905, or the Act of March 19, 1920. The phrase marks registered in the Patent and Trademark Office means registered marks. The term Act of March 3, 1881, Act of February 20, 1905, or Act of March 19, 1920, means the respective act is amended. A counterfeit is a spurious mark which is identical with or substantially indistinguishable from a registered mark. The term domain name means any alphanumeric designation which is registered with or assigned by any domain name registrar, domain name registry, or other domain name registration authority as part of an electronic address on the Internet. The term Internet has the meaning given that term in Section 230, subsection F, paragraph 1 of Title 47. Words used in the singular include the plural and vice versa. The intent of this chapter is to regulate commerce within the control of Congress by making actionable the deceptive and misleading use of marks in such commerce, to protect registered marks used in such commerce from interference by state or territorial legislation, to protect persons engaged in such commerce against unfair competition, to prevent fraud and deception in such commerce by the use of reproductions, copies, counterfeits, or colorable imitations of registered marks, and to provide rights and remedies stipulated by treaties and conventions respecting trademarks, trade names, and unfair competition entered into between the United States and foreign nations. Section 1128. Repealed. Public Law 110-403, Title 3, Section 305, Subsection A, Paragraph 1, October 13, 2008, 122 statutes at large, 4,270. Section 1129. Transferred. Section 1141. Definitions in this subchapter. Paragraph 1. Basic application. The term basic application means the application for the registration of a mark that has been filed with an office of a contracting party and that constitutes the basis for an application for the international registration of that mark. Paragraph 2. Basic registration. The term basic registration means the registration of a mark that has been granted by an office of a contracting party and that constitutes the basis for an application for the international registration of that mark. Paragraph 3. Contracting party. The term contracting party means any country or intergovernmental organization that is a party to the Madrid Protocol. Paragraph 4. Date of recordal. The term date of recordal means the date on which a request for extension of protection filed after an international registration is granted is recorded on the International Register. Paragraph 5. Declaration of bona fide intention to use the mark in commerce. The term declaration of bona fide intention to use the mark in commerce means a declaration that is signed by the applicant for or holder of an international registration who is seeking extension of protection of a mark to the United States, and that contains a statement that subparagraph A, the applicant or holder has a bona fide intention to use the mark in commerce. Subparagraph B, the person making the declaration believes himself or herself or the firm, corporation, or association in whose behalf he or she makes the declaration to be entitled to use the mark in commerce. And subparagraph C, no other person, firm, corporation, or association, to the best of his or her knowledge and belief, has the right to use such mark in commerce, either in the identical form of the mark, or in such near resemblance to the mark as to be likely, when used on or in connection with the goods of such other person, firm, corporation, or association, to cause confusion, mistake, or deception. Paragraph 6. Extension of protection. The term extension of protection means the protection resulting from an international registration that extends to the United States at the request of the holder of the international registration, in accordance with the Madrid Protocol. Paragraph 7. Holder of an international registration. A holder of an international registration is the natural or juristic person in whose name the international registration is recorded on the International Register. Paragraph 8. International application. The term international application means an application for international registration that is filed under the Madrid Protocol. Paragraph 9. International Bureau. The term International Bureau means the International Bureau of the World Intellectual Property Organization. Paragraph 10. International Register. The term International Register means the official collection of data concerning international registrations maintained by the International Bureau that the Madrid Protocol or its implementing regulations require or permit to be recorded. Paragraph 11. International Registration. The term international registration means the registration of a mark granted under the Madrid Protocol. Paragraph 12. International registration date. The term international registration date means the date assigned to the international registration by the International Bureau. Paragraph 13. Madrid Protocol. The term Madrid Protocol means the protocol relating to the Madrid Agreement concerning the international registration of marks adopted at Madrid, Spain on June 27, 1989. Paragraph 14. Notification of refusal. The term notification of refusal means the notice sent by the United States Patent and Trademark Office to the International Bureau declaring that an extension of protection cannot be granted. Paragraph 15. Office of a contracting party. The term office of a contracting party means subparagraph A, the office or governmental entity of a contracting party that is responsible for the registration of marks, or subparagraph B, the common office or governmental entity of more than one contracting party that is responsible for the registration of marks and is so recognized by the International Bureau. Paragraph 16. Office of Origin. The term Office of Origin means the office of a contracting party with which a basic application was filed or by which a basic registration was granted. Paragraph 17. Opposition period. The term opposition period means the time allowed for filing an opposition in the United States Patent and Trademark Office, including any extension of time granted under Section 1063 of this title. Section 1141. A. International applications based on United States applications or registrations. Subsection A in general. The owner of a basic application pending before the United States Patent and Trademark Office, or the owner of a basic registration granted by the United States Patent and Trademark Office, may file an international application by submitting to the United States Patent and Trademark Office a written application in such form, together with such fees as may be prescribed by the Director. Subsection B. Qualified owners. A qualified owner under subsection A shall, paragraph 1, be a national of the United States. Paragraph 2, be domiciled in the United States, or paragraph 3, have a real and effective industrial or commercial establishment in the United States. Section 1141B, certification of the international application. Subsection A, certification procedure. Upon the filing of an application for international registration and payment of the prescribed fees, the Director shall examine the international application for the purpose of certifying that the information contained in the international application corresponds to the information contained in the basic application or basic registration at the time of the certification. Subsection B, transmittal. Upon examination and certification of the international application, the Director shall transmit the international application to the International Bureau. Section 1141C. Restriction, abandonment, cancellation, or expiration of a basic application or basic registration. With respect to an international application transmitted to the International Bureau under Section 1141B of this title, the Director shall notify the International Bureau whenever the basic application or basic registration, which is the basis for the international application, has been restricted, abandoned, or canceled, or has expired, with respect to some or all of the goods and services listed in the international registration. Paragraph 1. Within 5 years after the international registration date, or paragraph 2. More than 5 years after the international registration date if the restriction, abandonment, or cancellation of the basic application or basic registration resulted from an action that began before the end of that 5-year period. Section 1141D, request for extension of protection subsequent to international registration. The holder of an international registration that is based upon a basic application filed with the United States Patent and Trademark Office, or a basic registration granted by the Patent and Trademark Office, may request an extension of protection of its international registration by filing such a request. Paragraph 1. Directly with the International Bureau, or Paragraph 2, with the United States Patent and Trademark Office for transmittal to the International Bureau, if the request is in such form and contains such transmittal fee as may be prescribed by the Director. Section 1141E, Extension of protection of an international registration to the United States under the Madrid Protocol. Subsection A in general. Subject to the provisions of Section 1141H of this title, the holder of an international registration shall be entitled to the benefits of extension of protection of that international registration to the United States to the extent necessary to give effect to any provision of the Madrid Protocol. Subsection B. If the United States' Office of Origin, where the United States Patent and Trademark Office is the office of origin for a trademark application or registration, any international registration based on such application or registration cannot be used to obtain the benefits of the Madrid Protocol in the United States. Section 1141F. Effect of filing a request for extension of protection of an international registration to the United States. Subsection A. Requirement for request for extension of protection. A request for extension of protection of an international registration to the United States that the International Bureau transmits to the United States Patent and Trademark Office shall be deemed to be properly filed in the United States if such request, when received by the International Bureau, has attached to it a declaration of bona fide intention to use the mark in commerce that is verified by the applicant for or holder of the international registration. Subsection B. Effect of proper filing. Unless extension of protection is refused under Section 1141H of this title, the proper filing of the request for extension of protection under subsection A shall constitute constructive use of the mark, conferring the same rights as those specified in Section 1057, subsection C of this title, as of the earliest of the following. Paragraph 1. The international registration date, if the request for extension of protection was filed in the international application. Paragraph 2. The date of recordal of the request for extension of protection, if the request for extension of protection was made after the international registration date. Paragraph 3. The date of priority claimed pursuant to Section 1141G of this title. Section 1141G. Right of priority for request for extension of protection to the United States. The holder of an international registration with a request for an extension of protection to the United States shall be entitled to claim a date of priority based on a right of priority within the meaning of Article 4 of the Paris Convention for the Protection of Industrial Property, if: Paragraph 1. The request for extension of protection contains a claim of priority, and Paragraph 2. The date of international registration or the date of the recordal of the request for extension of protection to the United States is not later than 6 months after the date of the first regular national filing, within the meaning of Article 4A3 of the Paris Convention for the Protection of Industrial Property, or a subsequent application, within the meaning of Article 4C4 of the Paris Convention for the Protection of Industrial Property. Section 1141H. Examination of and opposition to request for extension of protection. Notification of refusal. Subsection A. Examination and opposition. Paragraph 1. A request for extension of protection described in Section 1141F, subsection A of this title shall be examined as an application for registration on the principal register under this chapter. and if on such examination it appears that the applicant is entitled to extension of protection under this subchapter, the Director shall cause the mark to be published in the Official Gazette of the United States Patent and Trademark Office. Paragraph 2. Subject to the provisions of subsection C, a request for extension of protection under this subchapter shall be subject to opposition under Section 1063 of this title. Paragraph 3. Extension of protection shall not be refused on the ground that the mark has not been used in commerce. Paragraph 4. Extension of protection shall be refused to any mark not registrable on the principal register. Subsection B. Notification of refusal. If a request for extension of protection is refused under subsection A, the Director shall declare in a notification of refusal, as provided in subsection C, that the extension of protection cannot be granted, together with a statement of all grounds on which the refusal was based. Subsection C. Notice to International Bureau. Paragraph 1. Within 18 months after the date on which the International Bureau transmits to the Patent and Trademark Office a notification of a request for extension of protection, the Director shall transmit to the International Bureau any of the following that applies to such request. Subparagraph A. A notification of refusal based on an examination of the request for extension of protection. Subparagraph B. A notification of refusal based on the filing of an opposition to the request. Subparagraph C. A notification of the possibility that an opposition to the request may be filed after the end of that 18-month period. Paragraph 2. If the Director has sent a notification of the possibility of opposition under Paragraph 1, Subparagraph C, the Director shall, if applicable, transmit to the International Bureau a notification of refusal on the basis of the opposition, together with a statement of all the grounds for the opposition, within 7 months after the beginning of the opposition period or within 1 month after the end of the opposition period, whichever is earlier. Paragraph 3. If a notification of refusal of a request for extension of protection is transmitted under Paragraph 1 or 2, no grounds for refusal of such request other than those set forth in such notification may be transmitted to the International Bureau by the Director after the expiration of the time period set forth in Paragraph 1 or 2, as the case may be. Paragraph 4. If a notification specified in Paragraph 1 or 2 is not sent to the International Bureau within the time period set forth in such paragraph with respect to a request for extension of protection, the request for extension of protection shall not be refused, and the Director shall issue a certificate of extension of protection pursuant to the request. Subsection D. Designation of agent for service of process. In responding to a notification of refusal with respect to a mark, the holder of the international registration of the mark may designate, by a document filed in the United States Patent and Trademark Office, the name and address of a person residing in the United States on whom notices or process and proceedings affecting the mark may be served. Such notices or process may be served upon the person designated by leaving with that person or mailing to that person a copy thereof at the address specified in the last designation filed. If the person designated cannot be found at the address given in the last designation, or if the holder does not designate by a document filed in the United States Patent and Trademark Office the name and address of a person residing in the United States for service of notices or process and proceedings affecting the mark, the notice or process may be served on the Director. Section 1141I. Effect of extension of protection. Subsection A. Issuance of extension of protection. Unless a request for extension of protection is refused under Section 1141H of this title, the Director shall issue a certificate of extension of protection pursuant to the request, and shall cause notice of such certificate of extension of protection to be published in the official Gazette of the United States Patent and Trademark Office. Subsection B. Effective extension of protection. From the date on which a certificate of extension of protection is issued under subsection A. Paragraph 1. Such extension of protection shall have the same effect and validity as a registration on the principal register. And Paragraph 2. The holder of the international registration shall have the same rights and remedies as the owner of a registration on the principal register. Section 1141 Joules dependence of extension of protection to the United States on the underlying international registration. Subsection A. Effective cancellation of international registration. If the International Bureau notifies the United States Patent and Trademark Office of the cancellation of an international registration with respect to some or all of the goods and services listed in the international registration, the Director shall cancel any extension of protection to the United States with respect to such goods and services as of the date on which the international registration was canceled. Subsection B. Effective failure to renew international registration. If the International Bureau does not renew an international registration, the corresponding extension of protection to the United States shall cease to be valid as of the date of the expiration of the international registration. Subsection C. Transformation of an extension of protection into a United States application. The holder of an international registration canceled in whole or in part by the International Bureau at the request of the Office of Origin under Article 64 of the Madrid Protocol may file an application under Section 1051 or 126 of this title for the registration of the same mark for any of the goods and services to which the cancellation applies that were covered by an extension of protection to the United States based on that international registration. Such an application shall be treated as if it had been filed on the international registration date or the date of recordal of the request for extension of protection with the International Bureau, whichever date applies, and if the extension of protection enjoyed priority under Section 1141G of this title, shall enjoy the same priority. Such an application shall be entitled to the benefits conferred by this subsection only if the application is filed not later than 3 months after the date on which the international registration was canceled, in whole or in part, and only if the application complies with all the requirements of this chapter which apply to any application filed pursuant to Section 1051 or 11126 of this title. Section 1141K Duration Affidavits and Fees. Subsection A. Time periods for required affidavits. Each extension of protection for which a certificate has been issued under Section 1141I of this title shall remain in force for the term of the international registration upon which it is based, except that the extension of protection of any mark shall be canceled by the Director unless the holder of the international registration files in the United States Patent and Trademark Office affidavits that meet the requirements of subsection B within the following time periods. Paragraph 1. Within the 1-year period immediately preceding the expiration of 6 years following the date of issuance of the Certificate of Extension of Protection. Paragraph 2. Within the 1-year period immediately preceding the expiration of 10 years following the date of issuance of the Certificate of Extension of Protection, and each successive 10-year period following the date of issuance of the Certificate of Extension of Protection. Paragraph 3. The holder may file the affidavit required under this section within a grace period of 6 months after the end of the applicable time period established in paragraph 1 or 2. Together with the fee described in subsection B and the additional grace period surcharge prescribed by the Director. Subsection B. Requirements for affidavit. The affidavit referred to in subsection A shall, paragraph 1, subparagraph A, state that the mark is in use in commerce. Subparagraph B set forth the goods and services recited in the extension of protection on or in connection with which the mark is in use in commerce. Subparagraph C be accompanied by such number of specimens or facsimiles showing current use of the mark in commerce as may be required by the director, and subparagraph D be accompanied by the fee prescribed by the director, or paragraph 2. Subparagraph A set forth the goods and services recited in the extension of protection on or in connection with which the mark is not in use in commerce. Subparagraph B include a showing that any non-use is due to special circumstances which excuse such non-use and is not due to any intention to abandon the mark. And subparagraph C be accompanied by the fee prescribed by the director. Subsection C deficient affidavit. If any submission filed within the period set forth in subsection A is deficient, including that the affidavit was not filed in the name of the holder of the international registration, the deficiency may be corrected after the statutory time period, within the time prescribed after notification of the deficiency. Such submission shall be accompanied by the additional deficiency surcharge prescribed by the director. Subsection D notice of requirement. Special notice of the requirement for such affidavit shall be attached to each certificate of extension of protection. Subsection E notification of acceptance or refusal. The director shall notify the holder of the international registration who files any affidavit required by this section of the director's acceptance or refusal thereof, and, in the case of a refusal, the reasons therefor. Subsection F designation of resident for service of process and notices. If the holder of the international registration of the mark is not domiciled in the United States, the holder may designate by a document filed in the United States Patent and Trademark Office the name and address of a person resident in the United States on whom may be served notices or process and proceedings affecting the mark. Such notices or process may be served upon the person so designated by leaving with that person or mailing to that person a copy thereof at the address specified in the last designation so filed. If the person so designated cannot be found at the last designated address, or if the holder does not designate by a document filed in the United States Patent and Trademark Office the name and address of a person resident in the United States, on whom may be served notices or process in proceedings affecting the mark. Such notices or process may be served on the director. Section 1141 allows assignment of an extension of protection. An extension of protection may be assigned, together with the goodwill associated with the mark, only to a person who is a national is domiciled in, or has a bona fide and effective industrial or commercial establishment, either in a country that is a contracting party or in a country that is a member of an intergovernmental organization that is a contracting party. Section 1141M Incontestability. The period of continuous use prescribed under Section 1065 of this title for a mark covered by an extension of protection issued under this subchapter may begin no earlier than the date on which the director issues the certificate of the extension of protection under Section 1141 of this title, except as provided in Section 1141N of this title. Section 1141N Rights of Extension of Protection. When a United States registration and a subsequently issued certificate of extension of protection to the United States are owned by the same person, identify the same mark, and list the same goods or services, the extension of protection shall have the same rights that accrued to the registration prior to issuance of the certificate of extension of protection.